Your Lordship. I beg to mention item number 20 of today's list, Lordship. I have already taken consent from the other side, Lordship. In this case, Lordship, Mr. Advocate General supposed to appear, Lordship, and he is out of station, Lordship, today. So he will be available on 25th. Lordship may fix the matter next week, Lordship, just only Thursday, Lordship, 27.
Does it look nice of 2015 matter period, no?
I have already taken consent, Lordship, and
Then no consent is a
Assistant
different thing.
Counsel Mr. B. Gogoi also out of station, Lordship.
Who?
B. Gogoi.
Until he is not available out there, we have to keep.
He is also not available, Lordship.
So they know this matter is there.
As the
This matter, this
department
thing
also
of-
seeking Advocate General's representations in this matter, Lordship. This is the letter, Lordship, from the government, Lordship.
But if the Advocate General is not available, then can't help. Court can't wait for that. It is your.
For
If
today
this
only,
court
Lordship.
finds it that yes, the presence of the Advocate General is required, this court will obviously take note of that. But whether it is required or not,
As well as Mr. B. Gogoi also not here, Lordship. This is the problem,
he is not
Lordship.
available. But it's a 2015 matter.
Lordship, fix it on 27th, Lordship. Kindly accommodate, Lordship.
And then counsel appearing on behalf of the petitioner, they are
You
not.
can Lordship.
They don't want this matter to be resolved early.
They have consented today.
They're consented to. That means they don't want the matter to be resolved early. So we'll adjourn it. Sign it.
Already consented.
Why have you given the consent? Oh, is a 2015 matter? Does it look like to be there? Huh? Okay. I'm adjourning it. Sign it. Means you don't want it.
They express their difficulty.
Huh?
They express their
So what? If you have given the consent, then matter then adjourn, sign it. The 2015 matter.
Not today, Lordship. Because
name?
I have no file, Lordship, today.
Pardon me.
B. Bora.
T. Bora, the learned counsel for the respondent. You,
I am MP Sharma.
the MP Sharma appears on behalf of the petition. This is a writ petition. This writ petition has been pending since 2015, and almost 8 years have passed by. But the counsels appearing on behalf of the parties have agreed, have resolved amongst themselves that the matter needs to be adjourned, taking into account the same. This court adjourns the matter. Another?
No,
Find it?
still pending.
Let it come up after another 10 years.
No, Lordship.
Then
What the difficulty was there.
no,
Lordship may fix the matter on 25th, Lordship.
no, this court would not think that the learned counsels appearing on behalf of the parties are not willing to do the matter. The matter stands adjourned. I'll impose cost upon you. You couldn't have gone to an adjournment. Yes. Hmm? Yes. It is a motion matter. Matter pertains to. We'll have it on motion. We'll have it on 26. 26. Right, tomorrow. What is the urgency? So, is he going to retire before 26? Then why have you come at the last day? Not tomorrow, 26th. 26th of April.
Yeah, please, Lordship, in item number 48, I have filed one affidavit, madam. Mention for withdrawal.
Which one?
Withdrawal. Withdrawal.
Okay, you want to withdraw the matter.
Tomorrow.
Okay, we'll have it on 26th. Why?
Yeah, since when I have sent a pressure. I have sent a pressure, some difficulty.
You have a,
I have, after withdrawal, I have sent a pressure.
you want to file a fresh one?
Yes.
Okay, we'll take it up today. Today? Not possible. Then on 26th. Yes, Mr. Das.
Query with regard to item number 47, that orthotic university matter. If you
Huh?
want to- That orthotic university matter, item number 47. It can be taken a bit early, in the course of the day. Third on
Which
the
matter is this?
last, provision.
Oh, that 4.3.12 and 4.3, 4.2.13.
My lord,
That is it.
yes, my lord.
They are to produce the records today.
My lord.
We'll have it at 2.
Hi, lord.
What should may pay for application of item number 45 and 49?
45 and
49 year old.
why? These are all what? So these matters pertain to the suspension.
45 and 49.
Let's see. First, let us first pick up this 47. Then we will take a call whether to take it up on mention after 47. Yes, madam.
General list item number 1 to 19. Heard.
Lordship, I am appearing for item number 1 to 19. Lordship, matter may be passed over for timing as the senior is on leg another
So
question.
he knows this is the item number 1. He doesn't want to. We'll put it out there that he has not produced the record. We'll proceed accordingly. Yes, madam.
The last, taken
I've asked them to file an affidavit. They have not filed any affidavit out here. Under such circumstances, we will take it as if they have nothing to say. Now tell me out here. See, you have got the benefit in that appeal. Yes, you have not filed your affidavit.
45, the original record.
Huh?
I found the original record with respect to the description of the authority and the settlement.
Okay. No, but you have not filed the affidavit.
No, Lordship, yes, Lordship.
Okay. When was the search made?
It was on 2011, 2017. 2011, 2017.
And when was the assessment made?
Not
It was
6,
on 12, December
2019.
19. 2017, 19th
No,
December.
no, there are, if I remember correctly,
There was
this
20
matter.
days gap.
There was this. You say that there cannot be reasons to believe
Yes.
because of the fact that there has been already a
Assessment proceedings that reached almost final.
minor. Pursuant to the
Previous,
search.
2015.
Okay, now tell me the previous search date.
Previous search was 18, 3/9/2015.
3/9/2015
and it continued till 18/9/2015,
to 18/9/2015.
almost 15 days
Very well. So this is the search which was made, previous search.
previous.
Now, in pursuance thereto, there has been those materials were taken for the purpose of
Making assessment.
assessment. Now, for that, there was an assessment done.
Yes, yes.
When?
Assessment was on the verge of completion, lottery. All
When?
the years were taken from 10/11 to 16/17. All assessments were taken up.
10/11 to 16/17.
Yes, and 16/17 was selected manually for compulsory scrutiny category. Means they concentrated on 16 and 17.
Huh?
They took up 16 and 17 as the year, main year.
Understood. Anyway, 10/11 to 16/17. So they reopened under 153.
153A.
So they reopened and then they did the assessment, and the assessment was completed when?
Completed on this 14 and 12. 8/12/2007.
8/12,
2017.
2017.
Yes, yes,
So this was the assessment completed in all the cases.
yes.
Okay. Now, what was the fallout of this assessment?
Just before this assessment was completed, Lordship, on 20/11/2017, the search was made.
One day.
Not one day, Lordship, this is 20/11/2017, and the assessment was completed on 8/12/2017.
No, no, no. When was the second search made?
Second search is on 20/11/2017.
One day.
One day,
2011
2017.
second search.
Yes.
Okay. Very well. Now assessment was completed on the basis of the previous search. Now let us see what we can.
Assessment order is at page 77. Lordship.
What is this LTCG?
Long-term capital gain. The whole issue is about that long-term capital gain. We had purchased some shares to bank accounts, to be made demat account. Everything is recorded. It's accounted for.
Now what happened in the previous search which was made?
Previous search, Lordship, these recordings are there, Lordship, in the assessment order itself. Page 77 is the demand note, then page 78 is the order, detailed order. There it was. Paragraph 5. Sir.
Mr. Kyle, have you looked into these aspects of the matter? Have you looked into have you perused the reports which you
No,
have
sir.
produced?
I've just received it because it's come from Calcutta law.
Right.
I could not go through.
Because you see, earlier you have made a search.
Yes, that's the petition.
Now, while making the search, the basic reason why you have made the search is by initiating action under 131, it is not possible. By issuing summons, you can't get it. Therefore, it was necessary to make the search. This is the reason behind. If it is the first search, there is no problem with that issue. But if it is the second search, the problem arises. What happened? Why it was already done? And that aspect of the matter has not been taken into consideration in forming that opinion. Would it be correct? I hope you get my point. If it is the first search, obviously, 131 not possible by issuing summons, you can't get it. So initially going for a search. That's very well. But you have made a search in respect to those assessment years. Then why again the same opinion is being formed without taking into account that the earlier year also the search was being made?
But the record must,
Huh?
the record must reveal that what it was.
The record has to reveal.
So this, actually holding the file is the original notes while the search was conducted. What is there? Actually, I have not noticed.
Have a look. It refers to the same thing. Unless you say in your records that you have got hold of some other materials which has necessitated of changing the opinion, which has necessitated that the earlier search which was being made was redundant. There has to be something to this in the record.
Probably section 151 subject to correction of it. You have to provide that it is not restrict the authority from making multiple searches.
Understood. There can be multiple searches, but when you are again exercising the power, there has to be a condition precedent.
Satisfaction,
Have to have a reason to believe.
satisfaction is not much be there. At the authority.
But there was a previous search. If there was already a previous search, and if you don't take into consideration about the previous search and go ahead as if it is a new search again,
The reason must be disclosed in the record.
have a look at the reasons. Look here. Was in the first search, the long-term capital gain was not the issue.
That was it. I have to.
But you have to. I've given you so much time. You don't file your affidavit, and now you have to.
No, Lordship.
You seem to be not
Actually,
prepared.
the records were maintained by the Calcutta office. And purification number is not there. It reached to the morning of. And with respect to what's even the repetition, their challenge, the repetition ultimately is to be that way. Actually. They're challenging the search and seizure of 28/11/2017.
Yes, that is what they are searching.
And since
That is the second search.
No,
Yes.
no, Lordship, but there is no challenge to that. That earlier there was a challenge of second.
No. Their basic reasons for moving this petition is, look here, you have already searched. On the basis of that, you are proceeding with an assessment. What was the necessity for making a second search? Is it further? If it was said that, yes, during the assessment proceedings, it was found that no, these things couldn't be highlighted from the first search. Therefore, it was a necessity for making a second search. Okay, that's fine. That's a good condition precedent or reasons to believe. But it appears from the record there is nothing mentioned. Although it's from prima facie, I can say because I have not gone through the entire record. But
Lordship, allow me some time. I'll go through and I'll assist your Lordship.
I think better off. Who is this Anil Khemka? Anil Khemka. You don't know. What is this 21st century? Any street 21st century? You have no idea.
The companies for which we had purchased those shares. Now they are saying those companies have been declared over to something like that. But my transactions has happened through Demat account. I have paid through check. Those documents I have placed before the authority.
Now in the appeal, what has happened?
Last occasion, that is what I have claimed, the grounds of appeal and the facts which
Which
lordship
one?
wanted. Yes. These are in the format that we have to file lordship. The facts of the case and next is the grounds. In the grounds, they have not, I have found out lordship has gone through, they have not challenged the search, which according to my learned friend, search is.
Understood. What has happened in the appeal?
In the appeal has been, favored in our favor,
Appeal has been allowed.
allowed, and then tribunal also.
What is the ground on which the appeal was allowed?
These things have been considered already and the documents are there, Lord. All documents have been, again, the appellate authority again himself has asked from the authorities like stockholding corporation. He has taken the information from those departments and then he has passed this order.
So the appellate authority has the reason for interfering
Yes.
with the second assessment proceeding,
There
which
was
was
no
done
new-
pursuant to
yes.
the search.
Search. He
Is-
says that there is no new incriminating material because these LTC which they are talking about, this has been considered in the original assessment which was passed before the search in 2015. That is in 2000.
Now, why are you challenging the search?
Without any reason, again and again, first in 2000, they had made a search for block period, that was understood. In that assessment period, also in the block assessment period from 89 to 99, they didn't find anything. Whatever returns I had filed, my assessment was accordingly done. It was changed. Again, in 2015, they do a search, then they go for the assessments. Now, again in 2017, this is a routine work they are doing. That is what we are disturbed with. Because a search and seizure when it is done, it's not only all records and all has to be produced, the time of the businessman is wasted, plus the reputation of the businessman also goes. And when they do not have any reason, and even if they write any random reason, the courts have held or have made a comparison of those judgments. What is reason to believe, and like even if they have reasons, the court can always go, even if they do not go to the sufficiency of the reason, but they can at least find out whether they do not have any malafide in them. So,
Are you alleging malafide?
I'm not alleging that courts has the power like to go, like if the results are recorded, court has the power to go and to see if the reasons are.
So you are not against the materials which have come out during the search.
Yes.
You are
They-
only
they
on,
have
on
not-
the action of the search.
Yes, because they did not find any incriminating materials against.
So if we declare the search to be bad,
Yes.
but the law or the constitution bench of the Supreme Court has said that the materials can still be used.
Yes, materials can still be. But
So
there's
you
no-
have nothing to do, you have no problem with the materials being used.
Yes, there's no materials. at
No, no,
all.
you have no problem with the materials to be.
Yes, because they have.
You
not
want
found-
only on the basis that the continuous search which is going on.
Yes.
From all these, it is hurting the reputation of your company.
Yes.
That is the reason why you are challenging. Isn't it?
Yes, and they do not have any valid reason why they are conducting these searches again and again.
Understood. But you have no problem with the materials to be used.
So I do not have anything to hide. These are all recorded facts.
No, no, the materials which have been found out from the search, you have no material issues with that. So we will take it on the basis thereof. So let us see your statements made in your petition that why you are against the search.
Page 33, from page
Eight,
33 from
33.
paragraph 40.
Yes.
There is
Yeah.
that the petitioner was specifically takes to submit that in the instant case, the preconditions is envisaged under the provisions of section 312, lordship one, it will be 131, sorry, that's a typographical error, of the income tax act 1961.
No, this is that they didn't have the reasons to believe. Very well. No quarrel with that. Let us assume that they didn't have it. But why you agree with the search when the materials can be very well used? Why you are agreed with the search?
I am only agreed from on the ground that again and again they are, because this,
That is what,
they,
where is that statement? That is what I'm,
Lordship, paragraph 18, Lordship.
paragraph 18. Yeah.
Company submits that while the assessment be opened under section 153 of the Investment Act, in consequence of the search of 2015, on the basis of some information with investigation with Kolkata that the group in the financial year 11, 13 and 13 have made LTCC in the script of certain companies regarded as penny stock companies by the Income Tax Department and are at the final stage. The current search was again conducted in the year November 2017 on the same day. The said information cannot be considered as new information for the purpose of certain cases in the year 2017, as this information was already on record with the assessing officer as having been shown as tax exempt by the SAC.
Paragraph 19.
Yes. The petitioner humbly submits that the respondent authorities have conducted the search in the most mechanical way and with nullified offenses. A perusal of the assessment reassessment orders would reveal that out of the search in the year 1999 and 2015, nothing has come against the petitioner, and the assessment in respect of some of the assessment years were at its final stage. Even thereafter, for the same assessment years in question, certain Caesar have been made. The search in 2015, which was made was relevant to the period 1/4/2009 to 31/3/2016. The search in Caesar in the year 2017 is in respect to the years 1/4/2011 to 31/3/2018. Thereby, most of the years are in
But your
common.
prayer is not there. You don't have a prayer that no further search should be made. Or declaring that,
This
or
declared-
asking for, if you are asking as a constitutional thought, because if you are aggrieved otherwise, you have no grievance as regards the using of the materials. Your only grievance is that they are continuously harassing.
Yes.
It is a case of a constitutional thought. So if it is a issue of a constitutional thought, why should this court, why haven't you asked for any relief for
Future, in future, we have not asked.
then? How do
We
I
have
help
asked
you?
for only to declare this search as illegal.
Yeah. Then tell me. Couldn't there be a useless formality or unnecessarily picking up the court dwelling into an issue as regards a constitutional thought? Because your basic idea, the basic case out here is the case of constitutional thought that unnecessarily you have been harassed
Again,
by continuously.
and they should not do it in future. That we
But
have
can,
not-
can this court say then not to do it in future? The only thing is that if you are not agreed with the materials being taken, how can you help it?
Because there is no.
Unless you seek for compensation. That they have violated your rights and thereby some compensation is required.
Lordship, since petitioners, the humble petitioners, they need to do business also in future also. If they ask for compensation, future years gone for the petition.
Understood, but then also, if you are agreed with such action, if that is, otherwise if you have nothing, what remains of
Lordship,
it?
we have written the repeated certain Caesar is troubling.
Hmm?
We have written that.
Yes, repeated search, but are you willing to go ahead with the case by which you want to impose upon those persons concerned who have done the and asking for compensation from you?
If my lordship gives us the relief that the search is bad, maybe we'll file another case for compensation.
Why should I give you a relief that the search is bad? Unnecessarily holding the search is bad and then allowing them to use all these materials out there, that makes no sense. Why should this court unnecessarily? Because these are,
Because in the
wouldn't it come within the ambit of a luxury litigation?
because in the Panchama, they have already written that they have not found anything against
Very well, you should be happy with that. What remains now?
lordship, because since without a reason they have done this.
Understood, but then also you have got the relief in the appeal. Yes, there is no. I am telling you, there's no reasons out here which they have done.
So this open
And the income tax department is hopelessly prepared.
and the
But then also, if nothing can be done in view of the constitution, when judgment will, that the materials can very well be used. And upon using also this, their own department, the appellate the authority has categorically said that there's no incriminating material against you and the relief have already been granted to you. Why should this court unnecessarily dwell with the
Lordship,
issue?
we could not challenge the search procedure.
Understood, but search, if you are challenging for compensation, it is a very rightfully you have done, but you don't want to do that. Isn't it?
If I want to share one information, in the meantime, the petitioner approached the settlement commissioner for settlement of their case. In view of the matter, Lordship, whether their petition is maintainable. On one side, they are
You are
approaching,
troubling them and harassing him right, left and center, and therefore the petitioner is bound to go there.
no, Lordship, if it is so that they have been erased, let them approach your Lordship and by the original record, it reveal why there was a second search and where the second search was there. And Lordship, I am holding the assessment order, Lordship, just to see.
Which assessment not?
After the second search.
Hmm?
This is for the assessment year 2012.
Lordship, all these have been considered
All
in
the
this appellate process.
all the notes are there, Lordship, and the reason why the assessment was made, everything is reflected in the assessment order.
So? Don't turn this court into a commission of appeal.
No, Lordship, just for why
The
it was
court is not
made.
going to look into all those
What
things.
the
You don't
matter
have the courtesy to file an affidavit in spite of the direction given by the court,
No,
and
no,
now you are bringing into a, before this court, this,
No,
all these
in one
documents.
of the case, Lordship, affidavit is in file. We are, I'm relying, there is a case for all the cases.
Huh?
In one case,
I know the reason why you have not filed the affidavit.
No,
Because the question will arise, what is the new material available
no, that-
for making the search and search
No, Lordship,
when this assessment proceeding was going on?
Lordship, I have produced the original record for Kerujulu for Lordship. And Lordship, in the recent judgment, Lordship, last week when I submitted to Super Lordship, that was passed on 13/7/2022 in the case of Principal Director, Lordship Laljibai Kanjibai. Probably it must be available on the record. Lordship.
What does it say?
Lordship may come to paragraph 33.
Yes.
Paragraph 33. Conclusion. All the earlier judgments were considered, including that constitutional judgment also.
Yes.
Paragraph 33.
Hmm.
We would like to restate and elaborate the principle in exercising the jurisdiction in the matter of certain seizure under section 132 of the Act as follows.
Yes, what do you say about number 5? 33.5.
5.
3 and 5 are in my favor.
Such reason have to be placed before the honorable court. Lordship, we produce the original record before Lordship.
Read it. In total.
Such reasons may have to be placed before the High Court in the event of challenge to the formation of belief. The competent authority in which event the court would be entitled to examine the reasons for formation of the belief, though not sufficient or efficacy thereof. In other words, the court will examine whether the reasons recorded are actually by verified or by mere pretense, and that no extraneous or irrelevant material has been considered.
Now, the thing is as to whether it was a pretense or not.
Yes, sir.
When there is already, you have made a search. And in the second search, while forming the opinion, you have not taken into consideration the first search and the drawbacks of the first search. A case where, that is why I say, if it was the first search, the question is different. There's no quarrel with that, the first. But the second search, when you are making, don't you have to say that yes, first search, there was these problems which have resulted in that we need to make further. Isn't that the requirement, basic thing?
That must.
I'm not saying that, yeah, what is it saying? That it is not a quasi-judicial authority or judicial authority for which you don't require to give any reasons for that. Very well, no problem with it. But in forming the opinion, isn't it the requirement that the second search, while forming the opinion for the second search, the drawbacks in the first search needs to be taken note of that because of this is. I would have understood if it is from some other period, it is a different thing. But this is for the same period.
No, Lordship, it is extended up to 2019 law.
Huh?
The second search was two.
There is another 1617 was not there.
1819.
Huh?
Up to 1819.
No, no, 31st, 3, 2000.
No. First search was only for till 2000, and this assessment was made after the first search for which period?
For-
10, 11 to 16, 17.
Yes, and it's recorded in the assessment order also.
And in the second search also, this is being
Second
made
search-
for the same period.
For 1 year has increased, second search Lordship, till 31st, 3, 2018.
Where 10, 11 to 16, 17, it has been maintained. Now you have gone for some settlement.
Yes, that was my information. Lordship, today I received a call from the Calcutta office that the petitioner approached the settlement commissioner for settlement of their dues with respect to one company. A group of companies.
Now, is it in relation to all any of the petitioners here?
Yes, sir.
Maybe the petitioner is the same, but the assessment orders will be after this, maybe after 2018, 19, 20, 21. It might be regarding those years. After this. years, Lordship.
That day I was looking into another provision, which was that income tax act. Madam, I was looking into another provision. It was 100 and 132 B or recorded in August. So they are coming, they want to come under 132B.
Any person who is summoned or notice as opposed has or might be issued is not or would not produce or cause to be produced any books of accounts or other documents which will be useful for or relevant to any proceeding under the Indian Income Tax Act or under this act. They have already they have a recording in their assessment order that the representative has presented himself, replied to the notice. These are all recorded in this order also.
Well, understood, but the question is when they have already made the search. We have already made the search earlier for this some of the period,
Except 1 year, Lord.
except 1670.
Except 1718, Lord. Till 31st/3/2018, they had they said the new search is till 31st/3/2018.
Ah.
So that is regarding 1718. That
Hmm.
period is not.
That period is not there, but the earlier period is there.
Yes.
But in recording the opinion, they have not taken note of that period specifically. But madam, what remains to be decided now? You want Mr. Kyle, I think we should go through the reports one.
Lordship.
Better off.
My Lord, our humble prayer is that Lordship will give some sort of guideline that when they do the search, some sort of proper reason should be there. By their,
Has the Supreme Court not done till now?
but they are not listening to that. That may be
Huh?
they are not agreeing to that. That will be clarified. They are
You want this court's adherence and not the Supreme Court's adherence?
Lordship, that there is very much necessary at this point.
Let me look at the records because the problem arises. I would have understood if you have taken for 1718. There's no mention about that.
I'll go to and I'll let you. I'll keep for that later.
But the problem arises with the judgment of the Constitution bench judgment of, I think Justice Chandrachud.
70.
Huh?
Which one? Lordship?
Yeah, Justice Chandrachud's judgment.
74.
Something like that. I forgot the name. There the problem arises, which have not been touched. The materials used in, which have come into light in intermediate that can be very well used.
I know that is there in this judgment also, 22 judgment also, that the warrant was again said to be valid and which he has referred, that was said to be valid and the materials can be used. But they said that the court can always observe and can see whether the reasons are proper.
So looking into the reasons of proper or not, what does it make?
Lordship,
It will
where
be
the
only,
judgment
it will be a unnecessary time consuming
But
thing.
in my case,
Earlier, at one point of time, there were a lot of search which used to be made illegal. And then the matter had, and on the basis of that, it was held that the materials couldn't have been used. Otherwise, it doesn't make any sense.
but in my case, those things, whatever materials they're talking about, there is no material in fact.
Understood. So if there's no material, then nothing remains. You are only into the harassment.
Yes, that
If it is a harassment, then why haven't you not asked for constitutional thought for seeking compensation against them? And more particularly against the officer who have done it. This is a medium of party. This is a malafide action.
There is no respect to that effect of the petition.
And the paragraph 19 and 20, there is.
No, no, they said they're nullified, but nothing has been clearly stated, but
reputation and harassment of
What
family members,
else is
everything.
going to say? Malafide. Enough is there for 19 and 20. But the thing is that when you are alleging malafide, don't you have to make, you are not alleging malice in law, you are malice in fact. And if it is a malice in fact, then you have to make those people a party.
But the officer is a party,
Hmm?
investigating officer is a party.
You don't want to antagonize the specific persons.
Lordship, then my business is gone.
Then,
I have to close my business.
then in view of the appellate order, to bring a quietus to these matters, nothing remains.
No, Lordship, at least once this, if this court tells that this visa is valid, then they will, I think they will think twice before conducting any more.
But what does it make sense? Holding it illegal also. They can use it.
No, Lordship, they will think twice before conducting second against it.
They will follow the procedure, then they will be better in
They
putting
don't
the
follow
reasons out
They
there.
don't follow the procedure. That is the difficulty. Lordship.
sitting in another judgment, same judgment with regard to multiple search, in the case on 24th March 2023. Because almost in that case, paragraph is meeting slowly. If the summons on behalf of the respective SEC, the date of the last authorization to be considered for the purpose of starting point of limitation of 2 years. In that case, the entire object and purpose of explanation 2 to section 158 BE would be frustrated. If the said submission is accepted, in that case, the question which is required to be considered is what would happen to these materials collected during the search after the last Panchanama. It cannot be
But Mr.
disputed.
Kyle, tell me one thing. The Income Tax Act provides certain provisions that you can have the power of suo motu revision, have a power of reassessment. There's a limitation period,
2 years.
whatever maybe, 2 years or something given. Now, by way of a search, can you extend the period of limitation?
No, no. No.
Whereby going under 153 again?
Lordship, in this judgment that was dealt by.
If you can't make a reassessment, I'm telling you, if you can't make a reassessment, you can go for a suo motu revision. Suo motu revision you can very well do if it is erroneous to the area of the revenue. Or reassessment has to be done on the basis of certain formalities.
Yes, material.
You can't do that. So why not start the same process by going ahead with again another search? And thereby, again there will be a fresh assessment under 153A. Can you not then, although there are specific provisions out there, bypass those provisions I resort to a search illegally.
Illegally, we cannot proceed.
They
If,
can.
if suppose there is a.
Then isn't it the case then to challenge a search? Challenge a search or hold it to be illegal?
Petitioner can challenge, but the department to satisfy the code, what was the reason for first or second search? And there is no limitation for multiple search also. If suppose in first search, nothing could be seized, and on the information of further information, then second search can be done.
Well, but they have to indicate in committee
in
the
the,
opinion. That's
satisfaction,
the first search we didn't find that.
satisfaction note, it must be there, Lord.
There has to be
Yes, Lord.
that basic satisfaction. I am not asking for the reasons to state all the reasons or conclusion or judicial or the reason, recording of reasons in a, like a judicial, quasi-judicial authority or judicial authority. No, I'm not. But there has to be a basis.
Yes, Lord.
Has to be a material.
that-
That material, if it is not there, wouldn't it come within the ambit of a pretense to bypass reassessment or a suo motu revision by exercising power under 153A?
I've taken that
Huh?
paragraph. I've taken that in paragraph 20.
Oh, wait, you have taken that. Wait.
Paragraph 20.
She has taken.
And in this Anil Minda's judgment, Honorable Supreme Court says that that date, the date will be calculated from that the drawing of the Panchanama, not from the date of search or satisfaction note. So thereby, and it is within the 2 months, and it is also observed, it cannot be disputed that there may be number of searches. Thus, view taken by High Court that the date of Panchanama last drawn would be the relevant date for considering the period of limitation of provision. It is a recent judgment.
I hope you are not submitting that this search is a continuation of the 2015 search.
That if I have to.
Huh?
That I have to go to the
Well,
record, whether any notice.
Obviously, it can't be, because after 2 years, we are making a search. And there was a quietus receipt, and there was an assessment order done on the basis thereof. You have initiated proceedings under 153A.
Statement is that the assessment was on the last page. What? It was probably not completed.
No, that is the second one.
The first one.
No, as regards the first one.
First one. Lord.
Initially, assessment was done. Then there was a
Yes,
search.
search.
And pursuant to that, there was an assessment which was going on, and it was completed on 8/12/2007. No, not on that. But these assessment proceedings started because of you issuing a notice
Yes, Lord.
pursuant to the first search
That is there.
on the basis of the materials, and initiating a
Second search.
fresh assessment pursuant to 153A.
That was noticed.
Well, so obviously it can't be said to be a continuation.
Yes, Lord.
It can't be a continuation.
In that case.
That
So
is
if it is not a continuation, you have to have fresh reasons to believe.
Probably that.
And the fresh reasons to believe has to have the reason why the first search was not sufficient.
Materials must be there.
Well, look at it.
I'll go to and I'll assist you.
When?
After half an hour. After half an hour.
Half an hour. We'll have it on some other day.
All
We'll
of
have it on Tuesday. Next Tuesday.
Tuesday, Lord. Then Thursday, Lord. Because I am
Okay, Thursday.
not.
Read it properly.
Not.
Or Miss ML Gop, the learned counsel appearing on behalf of the petitioner. The SPK, the learned counsel appearing on behalf of the income tax. The SPK has produced the records sought for by this court as directed by the court on 23/3/2023. Mr. Kyle submits that he would like to go through the materials on the record as the same was only received in the morning hours of today. Accordingly, let this matter be taken up again on 27/3/4/2023 for further consideration.
Much of.
Madam, you think about, in the meantime, the constitutional thought
And I'll produce that order of settlement officer.
Ah,
Eh,
you get everything
Yes, I'll,
and you have not filed your affidavit.
Milord, this item may only be taken up for on Tuesday, Milord. I have to prepare a written out.
Okay. The request of Mr. Ita Gupta, the Palestinian reply. Ita. At the time, 25th.
Series item 22 to
So Goswami, you will be arguing this matter, there's 3733.
Millard, 3733.
It's the first one, item
No.
29.
No, Anima data, that is, I think, 3817 of 2020.
Item number 29. 29,
29.
29.
29.
And also, the other matter which can be kept.
And item 23
23.
means 29 is of 7 years, 23 is of 10 years. So there are two categories of food.
Let us first take out the 7 years of
11.
3817.
That file will be kept by him, Millard. That is item
They have filed the affidavit here.
2023.
In item 22, they have filed affidavit for all the matters.
22. 22 is item number and writ petition number
3733 of 2020.
373. Yes, okay.
And we have also filed a reply in each case. Huh?
In each case,
But your
for
lordship,
now, we have filed in 29 and 23 yesterday. But it will cover.
Let's know what is the
those
dispute.
replies can be requisitioned, Millard. Huh? Because, Hane, recorded. Your lordship may have to direct for bringing those replies.
So this is a case of retrospective provincialization.
Millard, what have happened is this, Millard, I'll just briefly give it a Millard, we have large number of venture schools in this state for a very long time. So this 2011 Act took the step of provincializing those ventures. And there was a provision as to how that process will be completed. Initially, it was 10 years, then in 2012, it was amended that the institution in question should be in existence from the date of affiliation or recognition or something for 7 years from 2006. 2006. So that is the provision. And the section 4, section 10 of the Act laid down the procedure as to how the verification will take place. And there was a schedule as to how many teachers will be eligible to be kept within the institution. All that was given, and a district scrutiny committee in each district was provided for. That is under section 10. 10.4. Which will see the requirement of eligibility for the institution as well as the eligibility requirement for the teacher in the light of the schedule given in the act. So each district had that district scrutiny committee. Composition was also specified, so it was done. So they first verify those things and then make a list and forward it to the director. That is the second. Director also can verify, and then it will send it to the state government department. And thereafter, the requirement of the preparation of that document, giving the name of the school, the teachers who are eligible, all these lists are prepared and made, and then let the process end. And once that institution is therefore provincialized, automatically under section 4, it won't be a lot, the teachers who are found eligible will be provincial by operation of law. It's a deeming clause which has been used there. Therefore, that process was going on and completed. When the validity of that act was challenged, and the High Court struck it down on 23/9/16. So prior thereto, Your Lordship will show the document. The process which was required to be gone into under the 2011 Act to find out the institutional eligibility as well as the employee eligibility was completed so far as these cases are concerned. And they were notified. in the
Whether the
West.
schools were provincialized
Yes, yes.
by under the 2011.
11.
So
And-
your case is that once the school is already provincialized, by deeming provision, the services of the teachers were also,
Were provincial. And when
and that
this-
is saved by the section 24 of the 2017.
and saved by 2017. What has happened in between is a state government filed a review of that judgment. The review was rejected, but in one paragraph, Your Lordship will find that those who have already got the benefit, the state can make provision for them to protect their rights. Para 19 of that judgment. which I have-
And that is how 24 came into
So
effect.
that is how Your Lordship will find in the new act, section 24, which protects that right which is accrued to the teacher under the giving clause of the. So that's the short form.
Because while I was dealing with the issue pertaining to old pension, new pension, one of the issues arose out here as regards whether the teachers who were appointed on ad hoc grant, which were being given to the venture schools, and their services were provincialized under the 2011 Act, wherein section 5 says gives the terms and conditions of the various of the teachers. It has been mentioned that they will come within the ambit of the new pension scheme. Now that act was struck down by the division bench. In fact, it was more like a consensus decision. But Advocate General have himself said that it goes against the ambit of the Right to Compulsory Education Act. A question therefore arose is that once the act has been struck down in that year, whether they will be still come within the ambit of section 5, the mandate wherein it says that they will come within the ambit of the new pension scheme. Now, referring to section 24, I've held that there, I didn't know about the review order, but referring to section 24, I've held that their rights are protected under the earlier act by virtue of section 24, subject to the fresh assessment required for their eligibility in terms with the section 4 of the new act.
For that,
The-
teacher
the-
or tutor.
So that aspect I have dealt with in the other case of that. So thereby I said that by virtue of section 5, they will come within the ambit of, because they have accepted once they have accepted their provincialization order on the basis of the 2011 Act, they can't now say that this section 5 would not come into being. For them, it is saved under section 24 of the 2017. So if I could understand what you have said, by virtue of the 2011 Act, the moment the schools have been provincialized, by deeming provision, their services were provincial. And as such, by section 24 of the 2017 Act, this is being saved. That of the respondent.
File, ultimately file the application. They have said that they are referring to one reference. That if this process is completed, it may be an administrative order to give effect to it. Because otherwise, by operation of law, they are only that is the view of Justice Procedural and also of Justice what it has been said. Therefore, the argument was that there must be some administrative order further to give them the right of provincial. But they said that by provincialized and
Of the 11 Act.
of the
Also Act section 4 mandates the same,
slightly different. Point out the difference between the
only subject to those conditions to be fulfilled before 2.
there is a slight difference
Yes.
under the old act, because it is provincialized by operation of law, living law. That your lordship will not find. There is a slight difference.
Let us then look into that.
Yes, kindly see that. Four seven. 4-7 is the first. Shall be deep the force of the act, and they shall become employees of the state except from that state, provided that the institutions have completed at least 7 years of in-person education, creation, completion, concurrence or permission, and the date of coming into so this, which the employee is by operation of law. Here. said that the services of those employees of venture education eligible for the under section 7 years of their incurred in it. As on the date of coming into
it will be either the date is 7 years and the date of recognition. If it is prior, 7 years is completed prior to coming into force of the act, it will be the date of the act. Or if it is after, then the date on which we complete the 7 years.
so if in both teaching and whether you need to display whom are provincialized or to be provincialized as specified in the
So proviso does not come.
No, proviso doesn't come. We are because we have completed.
In fact, that the difference is, I could see from section 4 of the new act,
Yes,
which stipulates is subject to the fulfillment of the other conditions of the
correct. That's the operation of law is not. That's very, very different.
that takes that subject to the fulfillment of other provisions of the act. Fulfillment
All other provisions of
there is a requirement of having a provincialization order as per the 2007, which is however not required for the 2011. But in higher education also, there is another, there also, the 2005, immediately on the effect of that particular act, by the beginning of it, takes it. Section 24.
section 24 you look. Cut down the by the order it is all teachers with services were provincialized shall continue and their places shall be reviewed as per eligibility.
So then they will be required to confirm in terms of 4.2 that they have this education 4.2, 5 and 6. We are not.
Otherwise, their right of provincialization
Now, does the 2011 Act stipulate a specific order to utilize? Specific order.
The date of the provisionalization of the
So it comes in effect by operation of law once you have 7 years.
Yes.
So there is no requirement.
also has the teachers also, those who fulfill the the number.
So that is the difference with the, that is the difference with the
Between the two.
where here there is a requirement of a provincialization of, which is not there in the order. And we are asking out here that you should be granted the benefit in the future.
Computer test process. This level. Yes, public. That is enough. Don't require individual object. And that is the new thing that this. Also follows that.
That has been settled by coordinate rate. So then,
Select that is that. Select that.
Robindranath,
Anima देखा के that is at 94, page 94. This judgment is at page 100. That Anima देखा case, which is 20.
yes, Dilip Das is at page 94.
Did not exceed the 4-1.
So he comes under 4.2, the petitioners, that within the schedule. So there is no quarrel, they have not denied to that in the affidavit. And have they filed any appeal against this order? Appeal has been filed?
No, I don't think.
orders have been implemented. And why, what is the thing about 10 years and 7 years? Was 10 years of affiliation. So thereby, those other institutions which had less than 3 years, from 10 years, also were brought with it. And in all this repetition, there is no quarrel that these people come within the ambit of this 10 years or 7 years. Petition and affidavit there, nothing 3817. Mr. Bora, every writ petitioner has its own cause of action. Don't you think so? Then, either is it me, there is only the 40 and only one person has been given. What about the deficit copy? Okay, has to be paid. Nowadays, after I have been sitting out there, I've been taking it seriously. Otherwise, this has been done. Matters. Yes. The copy has to be given. No, but this rule has been there for long. So these 7 years, all these things are just have to pay 124 first. Revenue provincialized. The cost of force for onwards of which so the coming into effect of this act will be from 15/11/2011. So you want your provincialization benefits from 15/11/2011.
Whoever has got it, they have got it from that.
If it is 10 years,
It is 1113.
10 years, it is 5th of September 2011. 10 years. The substitution happened by the Amendment Act of 2012 with effect from 15/11/2011. So those 10 years who were there, they will get the benefit from 5/9/2011. Because here if you see section 1, 2, 3, it shall come into force on such date as the state government made a notification in the official gazette point, and different dates may be appointed for different dates. In the Assam Extraordinary Gazette on 5th of September 2011. But in respect,
Section 4 and
how do you say so? Means the act has been given retrospective operation. No, here it has been mentioned specifically in 7 years substituted by subsection 1 and 2 of 2012 with effect from 15/11/2011. The whole of 2011.
section 4 and 8 was not brought into effect. That came subsequently from 1113.
Where you
That is at page 101, that notification, 12/5/17. Decided the powers conferred to
no, this is for the 2017 act.
Correct.
I'm saying about
Seem to have come into effect. Okay.
we are not concerned with this. We are concerned with the 11 act,
Right.
where for 10 years it has come into effect from 5th of September 2011. But for 7 years, it has come into effect from 15th of November 2011.
They have already got.
Now, if you see that, can we start to page 654 of that book? Then down below, you see, it has been substituted with effect from 15/11. So this has happened when 7 years was brought down to about 6 years, 6 years down to 2013.
brought down by just 30, I mean,
The amendment was given effect from when? It is date back to
that I can.
Has the government clarified that? You have the amendment of the
Amendment came from 7.15 days.
Yes, Mr. Katania. When does the 7 years come into being?
As part of Act number 1511, 2011, my lord.
In 11 is only in respect to amendment made to section 4.
Yes, sir.
We are not
Section
on
4.
that. 7, the 10 years which were there was reduced to 7 by the 2013 amendment. Because what is happening out here, it is being deemed. For a school will be deemed to have come into, it has 7 years, completed 7 years. And if it has not completed 7 years, it will deem to come into effect on the date it completes 7 years. Now, this was not the law at that point of time. When initially the act was coming to be, it came into sometime in 2013. Now, this was so their provincialization for those 7 years will come only effect only from 1/1/2013. But those who have been having 10 years will come from that date, 13/11. And what is the difference in the amendment which was affected? The difference in section 4 as it stood as on the date on which this act was brought in and subsequent amendment. Difference is different. The earlier act, prior to that, it was the province, they would be deemed to be employed with the government with effect from the date of the provincialization. But subsequently, it was made that they would become employed with the government from the date the coming into effect of that. That is the difference. So they will come to effect from yes. What is your stand?
This course of notification is required under section 10(4). I think come to page 650. There is a 3-stage procedure, my lord. That procedure has been followed by before it was done. The extent case, my lord, entire procedure has not been followed when the act was declared as ultra virus. First, my lord, there shall be one district screening committee in each district separately for elementary, secondary, and for higher education to scrutinize service records and other related issues of the serving teachers and staff of mental educational institutions pertaining to provincialization of their services. The deputy commissioner of the district by an order shall constitute the district screening committee for the respective district preceding subsection. The district committee shall first scrutinize and prepare a list of venture educational institutions within the district which are eligible in terms of the provisions of this act, and shall thereafter proceed to scrutinize and verify the service record of all the serving employees who are eligible or would become eligible for being considered for provision of their services. This is the first duty of the district scrutiny committee. Then, my lord, the district scrutiny committee shall forward the verified list of eligible teachers school-wise in accordance with the number of posts specified in the schedule appended to this act to the concerned director, who shall, after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institution and employees eligible for grant getting their services provincialized. So there is a requirement to issue the notification under section 10(4). That aspect has not been done in the instant case. If they are eligible, their cases will be considered by the district scrutiny committee. Thereafter, it is verified to the director's level. Then, if it is eligible in all respects, the director sent to the government for issuance of notification.
So here is also notification for eligible institution. Eligible institution. So I will say that there is no provincialization. Yes, sir. So this notification, that means the provincialization will happen. Not because it's section 4, but under
We have to read both the section 120. How do you use? First, there is a process to be followed. Because we have to find out under section 4 who are eligible, we have to find out. And the finding out procedure is specified in the section 4. And thereafter, in section 4, 10(4), there is a requirement to issue the notification. So that procedure has to be followed to keep the effect of provincialization.
Administrative officer. Let's take it again. Will affect the go where the file. That's what. Now let us see section 3. That's section 3 is the necessity of investigation for the purpose of eligibility as well as the selection.
For being considered for provincialization. does not have the required infrastructure.
Section 3, 4, and 3, 5. Section 3, 4.
An institution which does not have the required infrastructure specified in subsection 3 above may be considered as eligible for provincialization of the services of the employees, provided such institutions acquire the required infrastructure within 2 years from the date of commencement of this act. Subject to the provisions of this statute, ordinance, and regulations made by the concerned accrediting university in case of a degree college, and subject to the provisions of the right of children to free and compulsory education act 2009, in case of primary or upper primary school, or in case of all other institutions, subject to the provisions of the Assam Non-Government Educational Institutions Regulation and Management Act 2006, an educational institution which does not fulfill the eligibility criteria as on the date of coming into force of this act, or does not acquire eligibility under section 4 above within the 2 years period as opposed, shall not be eligible to be considered for provincialization the services of its employees, but may be allowed to run as a private institution or a non-government educational institution.
So, it is not only the requirement of 10 years or 7 years. Even this 3, 5,
Here, 2 years extended time has been granted. So, it doesn't fulfill the criteria at the time of.
so how are you going to work out? Section 4, section 3, 5, and section 10. Just read section 4. Or a college, which have been imparting education for 7 years from the date of affiliation, recognition, and conference of permission. The word "or" is either it will be affiliation or a hinges only on this. The college 5 to 7 years. That's affiliation, conference of permission. But what about the other requirement was mentioned in 3.5? Because institution does not have the provincialization by virtue of
That case,
for you.
yeah, I got the point. But I got my minus point. That's why, here 2 years time has been given to the school or colleges, whatever case may be, so that they can acquire the qualification within that period of time. If they get not acquire, then they will run as a non-government education.
So, provincialization, the right to be provincial, has to be on the basis of eligibility.
Exactly.
And the eligibility
Exactly.
is that your case. But there you have a problem. Don't you think about it? That is why these were the things which were brought into attention before the division bench by taking up this. And it was the specific provision to educate petition. A lot of this. And later, in section 4 of the new act,
Subject to fulfillment.
That is the difference. If you just imply section 4, by dint of having 10 years of recognition, a school or 7 years is automatically being along with the service. But if it does not have the infrastructure, then how do you beat then 3 and 4?
That qualification of the teachers. There also, mother, the time was granted.
Qualification that is, as of now also, this qualification can be met it up. They are given a tutor who doesn't have this qualification in terms with section 6. I'm not on that, but how do you read 3 and 4? Let us see in your affidavit what is your stand.
It's a 5 months. 811.
Affidavit in which
WPC 370.
have you stated?
But what categorically denying the correctness of the contention of the petitioners that they were found to be eligible for provincialization of their services under the Act of 2011, and accordingly their services were provincialized. The answering respondent humbly begs to state that the services of the petitioners have not been provincialized under the Act of 2011. It stated that though in some cases the district study committee forwarded the list of eligible teachers school-wide to the director under section 10 of the Act of 2011, however, no further steps were taken under section 10 of the Act of 2011 by the director before declaring the same act as ultra vires by this honorable court. As
But
such, the
Mr. Counsel said me, you must have gone into many judgments of the Supreme Court. And it seems to be starting taking up on because without such described even to be in 2011, that could be 5 years for deciding to it maybe a case of belief.
sometimes it may be a case of legal.
5 years is not a delay. You just do them 10 without taking 3-5, and 3-5 is not your case.
Earlier, different, school or different. That's why this categorically held that the requirement of same for
Where?
in the case of
With another
that in case of this also earlier in Dismissal case one Torun Singh, one Torun Das matter, Torun Nag. He filed the case challenging the recommendation of Dilip Nag. He was granted by the honorable court. Subsequently, that case was dismissed on the ground that the requirement of 10-4 has not been done that
So
time.
you are saying that the concurrent coordinate center
Yes, sir.
there is diversion.
Yes,
view.
my lord. Yes.
It's a case of reference. But you not develop the argument.
Why did when they want to delete that order?
The argument has you can't develop your argument on the laxity in the part of the authorities in completing a necessary thing as mandated under that. The argument has to be based upon that. But how do you read 3-5? If a case if it is not eligible in terms of 3, by virtue of 4, can it be on the basis of just having a recognition of 10 years before which that should be a specific case.
may grant you some more time so that I can.
With another affidavit.
No, I'm not putting any affidavit, madam. I'll try my
Another
best and-
time with another 1 lakh rupees. Fit.
so that I can develop my argument.
Because that is the reason why. I hope you have not read the 2016 judgment before coming in this matter. You read the 2016 judgment. By which 2011 act has been nullified. You read it?
Not to say not this, but earlier I.
That is the problem which the government was facing. And as such, it was a consensus. Government said, look here, this act is not in terms with the right to information, right to compulsory education. There is a lot of loopholes. And therefore, we are actively taking a decision to the regulator for having a new act. And on the basis of the consensus, this act was passed. And the government said that they are coming. See the words out there. The 2016 judgment. Though only a few provisions were challenged. Not all, the entire act was not challenged. Where is the reasonment here? It is also questionable whether the mode of entry into government service facilitated by the Provincialization Act can ignore the applicable reservation laws relating to SC/ST, women, disabled group. The role of the authorities in the field of education in the 6th schedule areas is also undermined by the 2011 Act. The appointment of the teachers in venture institution is not competition based and is opaque, and therefore quality of education is bound to suffer if this is allowed to continue. This naturally will negatively impact the next generation of our state. Moreover, the norms and qualifications prescribed by the competent authority like the UGC, NCT, SEBA, etc. is a major casualty in application of the Provincialization Act. When such substantial defects are perceived in a given context, the court can strike down only the offending provision. However, when the unconstitutional is noticed in the major provision, starting from the preamble to the schedule, striking down the offending provision will practically decapacitate the 2011 Act. In other words, the statute itself will become inoperable, although the ultra-virus declaration is limited to some segments of the Act. Therefore, we feel that a peaceful exercise will not serve the purpose, but in the same time to suggest how Provincialization Act could be reshaped, could be included into the domain of the legislature. Moreover, amendment exercise might have to be preceded by a consultative process with all the stakeholders and so on. You see, there will be specific submissions to that effect.
Yes, madam.
It is not workable. Section 4.2 read with the schedule to the provincial while provincializing the services of just two senior most teachers in the case of LP school and leave out the other teachers, and this according to the principle that discriminated against the teachers in the school, thus violating Article 14 of the Constitution. Submissions which are being made. How do you read? Can you read Section 4 in isolation without Section 3? No, you are saying. Mr. Katunia is the precedent. There are two divisions when two say coordinate them, wherein it says 10 is just administrative.
other two judgment minor.
And you are relying on 10-4D.
In fact, my lord, this is the judgment where, my lord, there is clear categorical finding that there is a requirement to notice on the 10th floor.
Where is it?
The 12 of the judgment.
Doesn't it?
There is a 12 months.
This is a prior judgment
Yes, sir.
on the same point.
Same point, madam.
This has not been taken into consideration.
There were all these different methods for whether the requirement of 10 is just the notification on the 10 is required or not. That was discussed, madam.
Not on the question of whether 10-4 is
Not on the
administered.
question of team provision, madam. Not on the question of team provision. But in Delhi, does
Then how does it, how are you saying that it is concrete?
the paragraph 12 manager.
Because at a time when the act was in force,
Yes, madam.
just the act was in force. Up to 1 day after that,
Both are September 2016.
went on 23rd of September. And this judgment is of 22nd of September.
Yes, madam.
1 day before.
And here, madam, paragraph 12, madam.
Is yet to be completed in terms. He said, he says that yes, it is a, there's no quarrel with that requirement. That 10-4 is a requirement which, but the moment you verify, and the provincial will take back to the date on their.
Yes, yes.
So, 10-4 is just to that point. Then once you verify, they get the benefit. Now, in this case, what has happened is, your thing is that that verification. And as such, the question of getting the benefit under the 2011 does not have. But this has been held back. That's the purpose. The fact that 10-4 is required, it's a statutory mandate, so they will do it. Huh? The verification has been. That's what I told you. This is of 2nd of June 2015. What is your provincial onwards, these are eligible And what is annexure B?
Starts at 134. Eligible for consideration under section 4(1) of the provisional.
Who has done this? When was this done? And our petitioners are here?
Yes, yes. That's why I said that, if you just have a look at page 138.
We will look into the additional affidavit. We thought it's not necessary.
In this case, madam, I have gotten copy, madam, but here only annexure A is here. Annex, madam, only annexure A. This file today, I have received the copy today morning, madam, at 10:30.
Which one?
Affidavit in reply, madam.
Now, this is also an affidavit. Affidavit in reply filed by the petitioner to the affidavit in opposition filed by respondent number 3. Only the data. Only the data.
Nirupama Boro. In my case, Nirupama Boro.
Any other cases? No.
Kindly translate 38 for a minute.
So this has been done. And in respect of all the petitioners we are having, it is there in annexure B. Those have not come. We have got copies. So we'll have it on some other day. Yeah. We improve your argument from that. No? We'll have it on, well, Mr. Usami, when? You have to pay 40. Yes. We'll have it after your convenience. Wednesday or Thursday, 27? Thursday. We can have it if you want. It's okay. Then we have to have it in the month of May. 2nd of May. 2nd of May. Appearing on behalf of also for a petition that in all the petitions that petitioners have filed their affidavit in reply. But those affidavit in replies are not on the court. They sound the same. This court deems it proper that the said affidavit in reply be brought to the court by the registry. And accordingly, let the matter be listed again on 2nd of May 2023. It further appears from the reports that against each various petition, But the court fee of only one pay. Council appearing on the council, Mr. B.P. Bora submits that will take appropriate steps for payment of the deficit court fee. This is the matter. Given to the police court.
Matter pertains to non-payment of salary.
It's just your last occasion. Whether the disciplinary proceeding is initiated on, as per my instruction, my lord, so cause notice was issued, but till date, no disciplinary proceeding.
What is this? So-called notice and disciplinary proceeding. So-called notice, isn't it the starting of a disciplinary
Starting
proceeding?
of it, but
Then?
other document is not applicable.
In fact, there was no reason, my lord. They have stopped my salary and then after 6 months issued me the first. In fact, they have punished me already for the wrong, which is in fact subject matter of the disciplinary.
He's working, is he suspended?
He is suspended, my lord. Initially, he was suspended, he was getting 50%. Now, as the suspension was not renewed and no DP was concluded, he is now getting 75%. Still under
Huh?
suspension. He is getting 75%.
Are you still suspended?
Yes.
This 2965 is for what?
2965 is for, my lord, the non-payment of the salary.
So at that point of time, were you suspended?
No, no. Proposal was issued to me in the month of January, my lord.
So this is January 2021, so-called was issued.
Yes.
And when were you suspended? Oh, you are not ready?
My lord.
Mr. Gupta, if you are not ready, this court has no time. There is other
Page
counsels
21,
waiting.
my lord, page 21.
Why should I look in the page 21? You tell me the
That is the
date.
date.
When were
date
you
of-
suspended?
Lord, by the same order, my lord, page 21, 7/1/21. It was placed in the suspension. On 7/1/2021,
Where is the order?
page 21.
Of which petition?
Of 2965.
So what is 53 for?
That is another set of writ petition, my lord, where the school managing committee members have challenged the order of transfer of the headmaster to their.
How is this connected with this?
Well, this is not connected, my lord. It is tagged on the prayer of the
Huh?
government council, my lord. That was tagged on the prayer of the. It is not connected.
It is not connected.
Not connected.
This is for same school, man.
Huh?
Same school, man.
The same school, the petitioner's right is different.
Maybe connected, my lord.
Here he is asking for his salary.
Yes.
Now you are getting subsistence allowance.
My lord.
You have not challenged the suspension.
I have not challenged it.
Okay, so you are entitled to the salary for this period from April 2020 to December 2020.
My lord.
And it's subsequent. Now, from when you have been receiving your subsistence allowance? January
January.
2021,
My lord.
we have got it.
My lord.
So we are only concerned with the period from April 2020 to December 2020. Yes, government, why have you not paid?
We have filed our affidavit, my lord, in paragraph 5, my lord. Page
What is
34,
your
running page
stand?
34, my lord.
Huh?
Our affidavit in opposition, my lord, paragraph
Yes.
5, we have stated, my lord. Page number 34. As a deponent denies the affirmation made in paragraph 3 of the writ petition, the deponent stated as per the report submitted by the district elementary education Nova, Kotatoka could not release the monthly salary due to not handing over the documents record to the regular headmaster Sofikul Haq Sudure. As the petitioner Ali Azam Hussain Anot was absent from his duty since 21/11/2020, while the district elementary education Nova Sakul being regional Kotatoka visited the school on the day he was absent. It is further stated that deponent that his present petition did not cooperate with the headmaster and the block elementary education Kotatoka, for which mid-day meal could not start.
For that, you take up, initiate action, do whatever you feel like, but why? Where is the question of not payment of salary? Isn't withholding a salary amounts to a penalty? Huh? 7(3). Then what do you say about Rule 9(1)? Or this rules of 1964 is foreign,
My lord, may I dispose of the matter?
for which department? Elementary?
Elementary.
Elementary does not follow rule. Rule of 64 is not applicable to. Is it applicable or not? Not applicable.
Applicable, my
Then, if it is applicable, then how are you doing it? How are you penalizing him? Who is penalizing?
CEO, my
Then? Video. Who is this video business? How can you do that? You want to stop his salaries, do it as per the provisions of law. You can't do that.
For the interest, my lord, because salary has been withheld immediately, my lord.
Hmm?
I'm also paying for interest on the, my lord. The government has illegally withhold my salary.
Hmm.
My lord, I'm also paying for interest. Judgment.
Judgment of what?
The Honorable Supreme Court.
Very well. And interest, who is going to pay? On the salary of the video.
Paragraph 13. Paragraph 13. The direction for the payment of the deferred portion of the salaries and pensions is unexceptional. Salaries are due to the employees of the state for services rendered. Salaries, in other words, constitute the rightful entitlement of the employee and are payable in accordance with law. The last paragraph, there can be no gainsaying the fact that the government which has delayed the payment of salaries and pensions should be directed to pay interest at an appropriate rate. Without any reason besides.
Yes, see, why should the state be burdened with the interest? Isn't it? To choose the respondent who was responsible will be deducted from their official his salary. Video.
CEO, block elementary education.
Okay, number 5. So we should take it from his salary.
That was COVID time. That was COVID time.
COVID time there was less expenses.
We are ready to pay, my lord.
What is the name of the BEO who was responsible at that relevant point of time? Is it the same BEO?
Bahari Islam.
Huh?
Bahari Islam.
We put him into notice. Which one do you want? If you want interest, we'll put him to notice about the interest. Huh? You want the interest, then we should put it. Why should we burden the state with the interest? It should go from his salary, who is responsible, including the director of elementary education. She has filed the affidavit justifying it. What is the director of elementary education's name? To put them to notice. Yes, Mr. Gupta. I only see paragraph 6 of his affidavit.
Documents are not required. Because even
Understood. Because these documents, you were put to notice that to give these documents.
I am the headmaster there, and the managing committee, members of the managing committee has not allowed the new headmaster to join. It is under the lock and key. Not that note I am not handing over.
Now, what is your reply? At paragraph 5 of your reply.
Yes, 48 months.
So under such circumstances, can you say that there was a laxity on the part to pay you the interest, to pay you the salary? No doubt, you are entitled to the salary for imposing interest upon. If you see the judgment of Justice Chandrasud in this, there was a clear-cut case of a laxity on the part of the officials, for which there was this imposition of interest. But we put it, ask him to pay by 1 month, and otherwise then we put interest. Mr. A. Gupta, the learned counsel appearing on behalf of the petitioner. Mr. B. Talukdar appears on behalf of the respondent number 1, 2, 4, and 5. Mr. H. Sharma appears for the respondent number 3. Petitioner herein is aggrieved by the action of the respondent authorities in not releasing the salary for the period from April 2020 to December 2020. It is a specific case of the petitioner that without initiating any departmental proceedings, stopping the salary amounts to penalty, which is contrary to the Assam Service Discipline and Appeal Rules 1964. It is under such circumstances that the instant writ petition has been filed for a direction upon the respondent numbers 4 and and 5 to release the area salary of the petitioner from April 2020 to December 2020 and its subsequent, as the same has been withheld illegally without valid reasons. At this stage, it may be relevant herein to mention that the petitioner was put under suspension in the month of January 2021. And thereupon, the petitioner had been receiving his subsistence allowance in terms with FR 53. Subsistence allowance 53. Of the FR and SR as applicable to the state of Assam. On the other hand, upon filing of the instant writ petition, it appears that this court had issued notice on 14/6/2021, making it returnable after 1 month. It appears on record that the Director of Elementary Education had filed an affidavit in opposition. From a perusal of the said affidavit in opposition, it transpires the reason behind withholding the salary of the petitioner was on the ground that the block elementary education officer, Botodraba, the respondent number 4 herein, who is the drawing and disbursing officer, had on several occasions served notice to the petitioner to submit all records and documents either to the headmaster or the block elementary education officer, Botodraba, to release the monthly salary, but the writ petitioner did not respond. There are various other allegations of misconduct as well as of financial irregularities mentioned in the affidavit in opposition. To the same affidavit in opposition, the petitioner had filed a reply denying to the allegations made against the petitioner. It is the specific stand of the petitioner herein that the petitioner was appointed as the headmaster of the school in Koichan, but he was not allowed to join, and as such, the question of handing over the documents did not arise, as the petitioner had no power and authority over the said documents in question. It is the allegation of financial irregularities, as have been alleged in the affidavit in opposition, have been denied by the petitioner and the affidavit in reply. It has also been mentioned that the petitioner was put under suspension illegally. To which the petitioner illegally, and there has been a show cause notice issued upon to the petitioner, which have been also duly replied by the petitioner. I've heard the learned counsel for the parties. The issue involved in the instant writ petition is as to whether the respondent authorities could have withheld the salary of the petitioner for the period from April 2020 to December 2020. Without there being any penalty being imposed. After conducting a disciplinary inquiry in terms with Rule 9 of the Rules of 1964. A perusal of the rules of 1964 and more particularly to Rule 9(1) of the rules of 1964, it stipulates that no order imposing on a government servant any of the penalties specified in Rule 7 shall be passed except after an inquiry held as far as may be in the manner provided in the said rule. The explanation to Rule 7 categorizes the various acts of the disciplinary authority which would not come within the ambit of penalty. Withholding the salary, however, would not come within the explanation to Rule 7 of the rules of 1964. Under such circumstances, the question of withholding the salary of the petitioner would amount to a penalty imposed that too without entailing an inquiry as required under Rule 9 of the rules of 1964. Admittedly, it is only in January 2021 certain disciplinary proceedings have been initiated against the petitioner. For alleged act of financial irregularities and misconduct. However, during this period of time, as admitted by the petitioner have been paid the subsistence allowances as permissible under law. The withholding of the salary, therefore, for the period from April 2020 to December 2020, in the opinion of this court, sends an order of penalty being imposed by following the due process would be impermissible. And accordingly, this court, in the interest of justice, directs the respondent authorities to forthwith release the salary of the petitioner for the period from April 2020 to December 2020, and not later than 31st of May 2023. It is, however, observed that in case the respondent authorities fail to do so, fail to release the salary, area salary of the petitioner for the period from April 2020 to December 2020, within the period as above mentioned, interest at the rate of 12% per annum shall accrue on the said amount from the date of such default. Apart from with the said, a copy of the instant order be served. The registry is directed to serve a copy of the instant order to Mr. B. Talukdar for communicating the concerned respondent authorities for payment of the salary, area salary, as directed herein above, within the time stipulated. With the above observations and directions, the petition stands forth. What is this 53? Who has filed it?
The 53 is filed by the school managing committee.
For what?
That is for, my lord, the,
You have filed.
no, my lord, I have not filed, my lord. This is
Then
by
why
the-
you are saying? Who are you? Where is Aktara Begum?
These are the people of the school managing committee.
What do they want?
They, my lord, they have challenged the order of transfer, my lord. A headmaster has been brought to their school. Which,
You, transfer of you, your transfer.
no, my lord, the other person's transfer. He is a private respondent, my lord.
Who is the lawyer for them? Oh, you are the lawyer.
Well, I am.
It is done at your behest. The entire proceedings.
No,
Then
my lord, it is a different proceeding, my lord. This is by the school managing committee, my lord. They have challenged the transfer of a incumbent who is involved in a corruption. So they don't, the school managing committee is opposing the transfer, that this person should not be brought to our school as a headmaster.
then
And thereafter, my lord, the honorable court during the pendency has also granted the status quo order. Order dated 12/2/2001, 21, my lord.
what school is this? The
Yes.
government school?
It's a government school.
And what is your business?
But we are the members of the school, parents, my lord, all the nearby residents who are nearby the school. They have, my lord, opposed that this person should not be bought because there are allegations of corruption and he will not be able to handle the school properly.
Right.
Yeah.
Too much. Huh?
But here service is awaited, my lord, on the private respondent. My lord.
Huh?
We taken up on some other service is also awaited on the
Service? Service against whom?
private respondent, my lord.
Service will look into it.
My lord.
First, satisfy this court. Why this court shouldn't dismiss your petition? Then nothing to worry with the service.
My lord, will produce the order dated 12/1/21
Of
in this
you want this court?
case only, my lord.
No, you want that your rights to get an order out here emanates from this 12/1/2021 order,
No, my lord, in the present,
not on the individual facts. Who are you?
my lord, the petitioners are the, my lord, the members of the managing committee.
School managing
School
committee.
managing committee.
The school managing committee, what do they do?
So their role is to, my lord, look after the functioning of the school. That the school
You
is
come under the
functioning.
2017 Act?
Yes.
Very well. What is the role of the school managing committee?
My lord, the duty is to ensure that the school is functioning in a proper.
All these are
Yes.
members of the school managing
Yes,
committee.
yes, my lord.
Hmm?
Yes. Parents are also there. Members and guardians of the
1,
students.
2, and 3 are members of the managing. Rest are guardians.
Guardians.
Okay. What is the allegation against him?
So the allegation is, my lord, the person who has been brought to the present school, posted as a headmaster, my lord, there was allegation against him that he had committed some irregularities in his previous school where he was posted.
And has he been inflicted with any punishment?
No, Lord, there are news allegations, no, Lord, newspaper, that will of the government authorities will say whether the action has been taken against him or not.
What?
No, Lord, that is for the government to say, no, Lord, whether the disciplinary action has been.
Are you both connected?
No.
This matter and that matter? Isn't it the same school?
School is same, yes.
Then
School
it is at your instigation this has happened. This person is transferred and brought in place of you.
Yes.
Huh?
Yes.
There.
But my lord, I am not here. I am not the petitioner.
Obviously, you can't be. You can't allege that somebody else of misconduct is there, so you
My
have
lord,
to
the
do.
ground on which the honorable court passed the interim order, my lord, will peruse the
No,
order.
no. I don't go on the basis of interim orders. No, interim orders does not create any right. But what right do you have? Who are you to say all these things? Unless there is an, on one hand, you are coming out here that without there be a disciplinary proceedings, how can they stop my salary? You are the lawyer for that.
My lord.
And now without there being a finding of misconduct, how are you saying that this person is corrupt? And isn't that an absolutely a decision of the administrative authority? Why does this court have to exercise writ in this matter? Or you want to make this this court a postman
No, my lord.
Huh?
Absolutely
for
not.
disposal of representation?
No, my lord.
That is your
No, the
prayer.
authorities are considering rather, my lord.
Let the authorities consider.
Yes.
You approach
This
this.
is the bona fide
You,
representation of.
no. I am vacating all this interim order business. You withdraw this petition, approach the authorities. 2020 representation and this court you want, this court should direct that finding consequent upon finding of inquiry, if it is found that a transfer order would be contrary to public interest. Sorry? What is this transfer order business of? Withdraw, dismiss which one? Dismiss, your right of representation goes.
What is to consider my representation?
No, nothing doing.
Because as a member of the school
Don't-
managing committee, my lord,
These type of orders is permissible in some other courts, not here. I don't want to act as a postman.
because my lord, the members of the school, they are bona fidely raising and grievance against the.
Let them do it. If they don't do it, don't do it. The authorities know. Are you alleging that the authorities are in hand in glove with this? Then obviously have some trust on these people. And because of this, there is a stay there. The earlier petitioner is still there in that school.
This is the petition.
Earlier petitioner, that petitioner is still there in that school.
Yes.
Yeah. See? Which one? Withdraw. Dismiss.
Not be fixed one date, my lord. I will take
No,
instructions, my lord.
No instruction, nothing, no business. You got this matter listed today before this.
Not-
I can give you some time. Let me take up another matter at 3. You get your instructions to withdraw or I dismiss.
My lord.
Tinta was Yes, Mr. Nair, your matter. 47. You mentioned original matter to 4.312.
Number 47.
Yes.
Well, on the last
Lord,
occasion.
Last occasion, Lordship asked for that, how that executive council meeting is regulated, what is the provision? And secondly, my lord, whether any notice was circulated. Yes, it was done. My lord. Well, as per the statutory provision, that is 2.3.2, my lord. The at page 1822,
2.4.
page 1822.
One
1822
of what?
statute, my lord.
Eight. I don't have so many pages. No, it is not.
No, no, 4.2. It is there.
Pink flag matter.
No.
1 week notice is required.
Executive committee.
Where? One
2.3.
meeting of the executive council.
Yes,
So
yes.
here the executive council has taken this.
That's the authority matter.
May be convened as frequently as it is found necessary by the mayor, but it must be at least clear. Notice of at least 1 week or now agenda.
Yes, my lord. No, ulta pulta bole.
Because the report, if I'm, the report was given on some
24.
23rd.
24/1/23
Yes,
and the EC meeting is on 25/1/23.
23 or 20. Then how did it form a part of the EC meeting?
my lord, the notice was issued on 12/11.
Understood, but how can it be form a part of the EC meeting if the agenda is not there to the meeting?
The agenda, my lord, meeting was called for on 12/11.
Understood.
Yes.
But a meeting is called for what?
To discuss amongst others, my lord, this issue.
How
My
can
lord,
this
that
be? Because
final
there is no,
resolution,
Because if we see out here, the
Yes.
action out here was taken only on the basis of the report by the vice chancellor.
Yes,
And the vice chancellor gave the report only on 24th. How can
Yes.
that be issue be there if the
Yeah.
before 1 week this was the report?
no, my lord, lordship will say whether there is substantial compliance with the requirement of the statute and the rules. Here is a case, my lord. As it is sought to be projected by the petitioner, that is not the case. All that with my lord, if your lordship would kindly have a look at that provisions. The first is a substantive provision and the later is the procedural part.
Regarding
That my lord 2.3.2 and 2. That confusion was there the other day, my lord.
4.2.
4 point, my lord. Now, if your lordship would kindly have a look at the impugned order at page number 51. 4.2.2.3 and 4.2.3.2. My lord, 4.2.2.3 is the, my lord, substantial part. That is the empowerment of the executive council. And 4.2.3.2 is the procedural part.
no, Mr. Chaudhary, on the last occasion, as I could understand,
Yes,
a right of a probationer is limited.
yes,
He may be asked to relieve from his duty.
yes.
That does not spring from.
No, my lord, the
From
case which is
4.2.2.
projected by my learned friend is very simple. He would like to say, since we have invoked, there is a mention of 4.2.2.3, therefore it must be founded on some allegation. Therefore, 311.2 is, imperative. That is the case he is trying to project. All that we are saying is, my lord, the power rests with the executive council. The procedure is 4.2.3.2. The latter portion, my lord. And this is the decision of the executive council, my lord. I am holding it. Lordship may go through it. There is no whisper of any, my lord, allegation or anything, my lord. All that the executive council took note was this, my lord. This is the executive council resolution, my lord. I'm just handing it over, my lord. In fact, agenda item number 19 was suitability assessment of Guru Prasad Khatonia.
How can there be a agenda?
My lord,
How can there be an agenda?
item.
Understood. How can there be an agenda out there unless there in the notice there is an agenda?
No, meeting was circulated. I have shown just now. 12:11. And my lord, not only that, on 23rd, they were also informed by mail. Well, I'm sorry, my lord, not 12:11, 12:1.
12.
My lord, all the executive council members were, my lord, notified. I have the honor to inform you that 8th meeting of the executive council of Bhattadev University is scheduled to be held on 25/1/23 at 10:30 AM in the conference of the detailed agenda minutes will be circulated shortly. This is the, my lord, notice.
When was the agenda circulated?
This one. মই কেছটো কৰোতো মই আগে আগে ফাইলটো উল্টা কৰিব নাপায় আছে তাতে গঠন চেক কৰি দিছে And my lord, apart from this, each individual members were also informed.
No, where is the agenda? When was it circulated?
It was subsequently.
When?
Subsequently.
No, that is a very important reason. The agenda will contain the term. As it is alleging of malafide out there.
No, my lord, what locus he has got to challenge the malafide, my lord?
Why not?
Malafide, we often say, end of the
No.
day, he must establish malafide.
No,
Yes, alleging malafide is one thing.
Malafide, malice
And-
in law
no,
as
my
well
lord.
as on malice
No,
in
lordship
fact.
will lordship will appreciate one thing.
Hmm.
Alleging malafide is very easy, my lord. But question is, end of the day, one has to establish malafide in the manner as has been,
Agenda will prove it. Because if the meeting was held on 25th, on 24th, you need 1 week's notice for that. Can you
Yes.
have an agenda at the time, can it be an agenda number 19? I would have understood any other items taken with the permission of the chair. Mr. Nair, have you looked into the judgment of Media One?
Media,
Media One?
Videocon.
Huh?
I can just get. Look.
Media One, that is the judgment of Justice Chandrasekhar, very late, recent judgment.
On my lord, provisional matter.
No, that is not. But there is a reference to a Canadian Supreme Court judgment on Urban versus Oaks.
No, my lord, lordship will
That's on a probation.
no, lordship will kindly appreciate one thing.
Hmm.
Now, it's true, my lord. Normally, ideally, the agenda should have been there. I admit. Anyway, my lord, my junior he's on legs, my lord, he handled with the records. What I find is, my lord, the other day, what the question cropped up was, when was the notice circulated for holding of the meeting?
Absolutely. Normally,
Yes.
Mr. Chaudhary, normally when a notice is circulated, the agenda is always a part of the
Supposing, my
notice.
lord, supposing
But
it
if
is,
you have said
No,
it,
no.
that you will have it shortly.
supposing it is not there, will it be fatal in every case?
No, if it was not there in the agenda,
What I'm saying is, supposing it is not there, end of the day, my lord, each and every component has to constitute a wrong.
Hmm.
Now, that is not their allegation. His case is very simple. The case he is projecting is, since we have referred to 4.2.2.3, therefore it must have been founded on some misconduct, therefore 311(2) is attractive. That is his only case. We have answered that case, my lord, in the writ petition, my lord, he has not founded any other case. Writ petition, his case is very simple. That there's some because there was a police case, because I was arrested, because my misconduct has been taken note of. Therefore, my lord, this 311 is attracted. Since it was not not applied, therefore the action is wrong. That is the case he has made out in the writ petition. That is how we have answered in our affidavit. Now, question is, our case is totally different. Our case is, we have judged his suitability, we have found him unsuitable. That is the substantial part of it, my lord. Now, the records which I produced, my lord, I think lordship has seen that agenda item number 19. Please have a look at it, my lord. Therefore, my lord, thereafter, my lord, if a lordship feels that there is shortcomings, I leave it to a lordship's mind. Kindly have a look at the records, and I'll place 2-3 judgments on the point. My lord, we cannot be taken by surprise at the time of hearing. It is the fundamental requirement of pleadings that the party must, lay the foundation in the pleadings. If they don't, they cannot argue with it.
Rather, we are surprised because the impugn order does not show anything.
hmm,
The impugn order, it's only the number. There is no date of the EC meeting. Neither there it is mentioned that the Vice Chancellor had made this recommendation a day.
Notice to accompany for Mailer question agenda. Agenda দিব লাগে তাতে পয়সা এজেন্ডা ফলো করতে এখন কোনো বাচ্চা কোড কোয়া এজেন্ডাটো ক'ত এইটো 19 নম্বৰ এজেন্ডাটো আমাৰ ক'ত agenda? কোৱা, কি আছে? Also not that.
ইয়াতে হেৰি হিচাপে গুচি গৈছে এজেণ্ডাৰ এই attachment, হা? গতিকে attachment তিনি মানুহৰ তাতে দি পঠাই দিছে।
আমাৰ 8 মিটিং আছে নহয়।
এইটো আৰু আগৰ মিটিং ৰেটিফাই কৰিব লাগে এই যদি আপুনি
ৰেকৰ্ডত কিয় নাই?
এইটো যিটো খোলে এইটো কাটি ওলাই যাব কোনটো এই PDF ফাইলটো খোলাৰ লগে লগে এজেণ্ডাটো দেখোন কেইটা ওলাই attachment হিচাপে গুচি গৈছে।
কোনো কপি আৰু নাই। এইটো আছে। My lord, agenda was circulated, my lord, subsequent. দেখা যেতেই আছে।
Mr. Chaudhary, is this a part of the record?
Yes,
You have filed it.
no, we have not filed.
So under such, are you claiming privilege?
No, my lord.
Then I think you should give him a copy. Let him
Yes.
look in, because the thing is.
My lord, my learned friend would have claimed privilege. I don't, my lord. He would have definitely.
But then,
When I have seen when he appears on this side, he has the habit of claiming privilege. I don't, my lord. End of the day, my lord, this is nothing to do with, my lord, security of the state.
It's very easy to
My
give
lord,
open
I have-
statements. If he has instances, let him produce more. I've never done that.
let's not go
এখন record
into
over,
with
right?
personal attack.
No, but
But
that-
only thing is,
the person attack
I'm
should be
only
issued.
saying out
That's
here.
all.
No, I'm only asking because sometimes
No, I'm
uh,
not.
I request.
somebody
No, I'm
would
not
like to
claiming.
claim privilege.
Fine, my lord.
If
No, my
not,
lord,
why not he
no, my
have a
lord,
look at it?
My lord, we cannot claim privilege in respect of each and every document. I think section 123 and 162 of the Evidence Act is very clear, my lord, in respect of which document we can claim privilege. And my lord, in the affidavit, we have also craved leave to refer to this.
এই কাগজখন নিয়ে- এই কাগজখন নিয়ে- এটা right link. এই notice-খন
My lord, the other day, my learned friend was also making an argument that, my lord, at the end of the period of provision, we should have made the assessment. এখন দিলা নে?
notice.
Notice. All right. গোটেই বাঞ্চ দিলো মেইলখন দিলো
এই যে তেওঁলোকক যে notice-খন যে আমি mail-ত দিছো,
নহয় সেইটো কোৰ্টে বিচৰা নাই কোৰ্টে হেৰিটোৱে বিচাৰিছে
তেজটো ওলাই কৰিব, mail-ত তেজটো produce কৰিব নোৱাৰে।
And where is the agenda?
My lord,
First PDF.
No, this is only the email.
I think one mail in the mail attachment is there, my lord. Agenda for the 8th executive committee meeting.
Committee agenda.
সেইটো দেখাই দিয়া বুজাই এইটো ফুল PDF
এই যে আমাৰ নাই, এইখনৰ লগত agendaখন এনেকুৱা one হৈ আছে। এইটোৱে
এজেন্ট আমাকে উন্মোচন করে
PDF file হয়ে গেছে, eligible record থেকে একটু তাতে annex এর one যেন একটা খালি থাকে। Yes.
मीटिंग और एजेंडा है
PDF file করে দিই।
that item serial number 19 matter.
When did you come to know about his filing the case? When did you issue the notice?
After issuance of notice matter.
When was it?
I'll just notice issue. Or suspension case. My lord, in this matter, notices were issued on 15/3.
Industry service also permit.
10/2. It's on 28 to no, it.
It will. I think, my lord, in this case, we appeared on caveat, my lord.
No, not here.
In the
earlier
other
matter.
case, pursuant to the notice, we appeared.
Because if I remember, Mr. Nair had made a submission at that point of time on the first day that pursuant to the issuance of notice, this vindictive attitude has been taken.
28/11.
But when was the notice issued?
28/11.
You see, you said that on the very day on which you have served
Lordship,
the notice
Lordship,
through Dusty,
Lordship.
on that very day you got that termination order or something to that effect?
Maybe my lord, a few days thereafter.
I remember.
I think notice was issued in November, my lord, and termination is of February, January, 31st of January. এইবিলাক submission দিয়ে আকৌ সেইকাৰণে কৰোঁতে মনত ৰাখিছে
I'm just giving it. Let me go 712. No, no, E2. Itu case number gimana tuh? 75.
And where is the Vice Chancellor's note?
24th, my lord. Yes,
You have it?
yes. এইখানে না?
Mr. Chaudhary, we'll have it on 27th. Give him a copy of this Vice Chancellor's assessment as well as the
Minor
resolution adopted, more particularly resolution 18 and 19 to him.
My lord I can have the whole resolution. I can know the quorum also.
Huh?
The quorum of the meeting. I can also understand the quorum.
The entire resolution, ask your junior to give him a copy. You heard Mr. U.K. Nair, the learned counsel, senior counsel assisted by Mr. H.K. Das, the learned counsel appearing on behalf of the petitioner. Mr. Kane Chaudhary, the learned senior counsel assisted by Mr. J. Papar, learned counsel appearing on behalf of the respondent number 3, 4, and 5. Mr. I. Chaudhary, the learned senior counsel assisted by Mr. S. Vishwakarma, appearing on behalf of the respondent number 8. Mr. S. Wait, yes.
I appear for tea.
No, that I put it. No, SEPA and all this. Okay. Mr. Kane Chaudhary,
My lord,
the learned senior counsel has, during the course of the arguments, placed before this court the notice issued to the members of the executive council, executive committee council on 12/1/2023 the minute of the 8th Executive Council meeting of the respondent number 3 university held on 25/1/2023, as well as the assessment performance of the petitioner by the Vice Chancellor of the respondent number 3 university on 24/1/2023. Along with that, an email issued by the Register Bhattadev University dated 24/1/2023 at 3:15.03 hours was also produced before this court as well as email dated 24/1/2023 at 15.03 hours and 25/1/2023 at 11:46 hours were also produced before this court. Mr. Chaudhary, there are two agendas. There are two agendas.
Earlier agenda for approval, my lord.
No. There are two agendas. First is the agenda.
No, agenda,
Of-
there are in the last, after that, my lord, minus, my lord, there is a list of the agenda. Item number
Under-
19
no,
pertain to this.
There are two agendas. The first agenda is being issued on 24/1/2023 at 15:03 hours. The second email says about the revised agenda,
Yes.
which was issued on 25/1/2023 at 11:46 hours. So which are the two agendas? The learned counsel for the petitioner submits that the petitioner be given a copy of those documents so that the petitioner can have a look at it. Taking into account the Mr. J.P. Patwari, the learned counsel appearing on behalf of the respondent number 3, 4, and 5, is directed to give photocopies of these documents referred to herein above during the course of the day. This is the matter again on 27/4/2023 for further consideration. It would be, let us not, we will again take it up on that day.
I
You
will
just,
bring again, my lord. The records are with us.
yes.
No, the liberty to upgrade is there.
Huh?
Liberty to upgrade if.
Liberty is given to operate. I hope by then you can improve your case.
Not- Those documents.
My
But
lord,
this judgment
Not
is a judgment of the Canadian Supreme Court. You may have a look at it on the right of a probationer. While developing the law of proportionality, while developing the law on natural justice, the Supreme Court was taking note of that judgment of the Supreme Court of the Canada.
our Supreme Court, my lord,
Yes,
from
our
Canada.
Supreme Court had to refer to that judgment, Urban versus Oaks or something. I forgot the- You'll get in that media one judgment.
Media one, I'll have.
My lord gave us liberty regarding the other matter after this matter.
Oh, yes.
There are two matters, what will take one of them today.
Only one. Which one do you choose?
Prasanto Dotto, my lord, is behind more than 1 year. My lord.
The longer is the suspension period, we'll take that one.
Yes, Prasanto Dotto,
I'm coming in 5.
my lord.
No.
43.
Where? Mr. H. Gupta?
sorry, my lord. My lord, in this petition, my lord, may I pray, my lord, to produce paragraph 13 for him. Paragraph 13 of my writ petition, my lord, where from the right of the school managing committee has come, my lord, that part, my lord, I just wanted to play. My lord, Rule 13(8) of the Assam Right of Child to Free and Compulsory Education Rules 2011. My lord,
Era?
paragraph 13, my lord, second paragraph, my lord, from the bottom last 4 lines, my lord, last 5 lines. Under Rule 13(8) of the Assam Right to Child to Free and Compulsory Education Rules 2011, under the headings Powers and Functions of the School Managing Committee, it is stated that the School Managing Committee shall take all necessary steps for the growth and development of the school, leading to an educational environment conducive for the attainment of academic excellence by the children. So, my lord, this is the bona fide apprehension of the school managing committee, and my lord, my prayer in the writ petition is very innocuous, my lord. I am just praying that,
No, it is not innocuous.
my lord, may peruse my prayer, my lord, for a moment, my lord. Because I am no way, my lord.
It is not innocuous. We have no business out there to say anything on this transfer thing.
Because the allegations are serious, my lord. If I may,
What are the
say, my lord, to
allegations
annexure
again? What
A
is the
page.
allegation against the respondent number 5?
This respondent was earlier, my lord, transferred to another school. My lord will see page 12, annexure A.
Yes.
Again, he could not join. My lord will see page 12, annexure A. In partial modification of this office earlier issued wide under memo dated 39/2019, Safikul Haq Chaudhary, headmaster, is hereby reposted at Haidupi Rampur Satra Boys MEM, Vice Muhammad Yusuf Iraka, headmaster, retired under PO, as he could not join at Singari MEM under. Earlier also, my lord, he joined there. The people opposed. He could not join. And my lord, in the next page, the next B is the newspaper article.
So newspaper article can be the basis?
No, my lord, it
Then-
cannot be, my lord. But what the managing committee is simply praying that the authorities should take into consideration the
Nothing doing all
representation.
this thing. On one
Because-
hand, your person out there is under suspension.
We are not saying, my lord.
There is also a
without
serious
inquiry,
allegation against that person concerned from whom you represented.
my lord.
There is a serious concern that he is involved in financial irregularities as regards midday meal.
My lord.
You denied it.
Yes.
I hope you denied.
My lord. Yes.
This is only a newspaper article.
Here also, what I am praying is, my lord, after inquiry, my lord will see my prayer. Consequently, upon findings of the inquiry, if it is found, it is not that, my lord, I am
Consequently, where?
my prayer, my lord, at page 10.
Hmm.
My lord, I have made 2 prayers as to why the respondent authority should not be directed to give due consideration to the public complaints representation dated 1/2/20 and 30.
Reason speaking order, and after holding a due inquiry. Then
That is only, my lord. It is not that my intention is to retain as a
which one do
headmaster
you
there.
want? Dismissal, withdrawal? Which one? Question of an interim order in a transfer matter of this type? No, nothing. Which option? I'm giving you an option.
But my prayer, Lord, for instruction, my lord, will pass the orders on merit.
Okay. Heard Mr. H. Gupta, the learned counsel for the petitioner.
B Talukdar.
Mr. B. Talukdar
For
appears on
elementary
behalf of the respondent numbers
1, 2,
1,
Three,
2, 3,
and
and
4.
4. Full stop. The petitioners before this court have challenged an order of transfer dated where is the order of
My lord,
transfer?
I have not challenged the order of transfer, my lord. The order of transfer is not challenged.
Okay, have
Page 12 is the order, my lord, which
where is the order of transfer?
page 12. And it's at 8.
The petitioners before this court are members belonging to the managing committee of Habidubi Rampur Satra Boys MEM, as well as the guardians of the students of the locality. Who have submitted representations to the respondent authorities on 1/2/2020 and 30/8/2020. With a prayer to not allow the respondent number 5 to join the said school. Who was transferred by the Director of Elementary Education, Assam, by an order dated 22/1/2020. The allegations so made as would appear from a perusal of the representations so submitted on, what is the date of the first representation? Annexure C.
One to 2020, my lord.
The allegations so made in the representation dated 1/2/2020 it was decided in a meeting held by the public not to allow the respondent number 5 to join the school due to massive corruption and misconduct. For which the respondent number 5 was transferred from one school to another. It was alleged in the representation that the petition, that representation, that the respondent number 5 was involved in massive corruption and illegalities with regard to finance and midday meal, for which the petition, the respondent number 5 was transferred. The said said representation was submitted to the District Elementary Education Officer, Nagaon. Subsequent thereto, after a passage of almost 7 months, another representation was submitted. Not to transfer the respondent number 5 not to give effect to the order of transfer dated 22/1/2020, and to transfer the respondent number 5 to any other school. This court made a specific query upon the learned counsel appearing on behalf of the petitioner. As to what is the basis of the allegations. What is the basis on which the allegations have been made in the representations? The learned counsel for the petitioner have drawn the attention to a news article published in a news daily on 18th of June 2019. As the entire gambit of, as the entire as the reason behind issue submission of the representations. Where on the basis of a newspaper, unverified newspaper article this court finds no reason to issue a mandamus upon the respondent authorities to conduct any inquiry or to consider the representation submitted by the petitioners. আগৰ petitionখন dispose কৰিছিল নহয় কিটা At this stage, this court further finds it relevant to take note of another writ petition. You have the copy of the earlier writ petition? Writ petition? I disposed of, na?
2965.
You don't have the file?
My lord, already I sent.
Everybody is so far. Clear line 2. This court further finds it relevant to take note of that the instant writ petition was listed along with another writ petition today, that is WPC number 2965/2021. The said writ petition was filed by the existing headmaster of the said school. One Ali Azam Hussain. Noteworthy to mention that in both the writ petition, the lawyer happens to be the same. While the order dated 12/1/2020 issued by the Director of Elementary Education, whereby the respondent number 5 was brought in place of the said Ali Azam Hussain and this very person, namely Ali Azam Hussain, have categorically mentioned in paragraph number 10 of the writ petition that the said that the respondent number 5 never joined in the school, and in fact he was not allowed to join in the school by the managing committee of the school for his past bad records, wherefrom he was transferred to the said school. In the said writ petition, in paragraph number 10 of the said writ petition, it was further mentioned that the transfer and joining of the respondent number 5 was sub judice before this court in the present writ petition. And this court, by an order dated 12/1/2021, had directed to maintain status quo. From the above, therefore, it would be seen that not only the entire case of the petitioners herein is based upon an unverified news article, but it also appears not to be bona fide. And seems to be done at the behest of the existing principal, headmaster of the school. Under such circumstances, this court is not inclined to issue the prerogative writ of a mandamus, directing the respondent authority to consider the representation and have an inquiry as regards the allegations of the petition, allegations made against the respondent number 5 in the present facts and circumstances. In that view of the matter, the instant writ petition therefore stands dismissed. Cost 50,000. We divide it 25 to you and 25 to the other.
No, my lord.
Huh?
Okay, but no, not for cost.
What?
Because
Mr. Gupta, you have to be serious.
Hello.
You are a standing counsel of the central government. You
Not I have
You go into this type of litigations, you know this litigation. You know that it is at the behest of the other person.
I've been represented.
Then the interim order dated 12/1/2021 stands vacated. Before parting with the record, this court, however, observes that the respondent authorities is observed that the respondent authorities shall take such appropriate steps as deemed necessary in the interest of the school. Right. Mr. Gupta, next time don't bring up with petitions of this type. Yes, Mr. Chaudhary, your matter. Mr. Chaudhary, I'm put into a lot of predicament with this particular judgment of the division bench. Have you looked into it? It is something like the operation was successful,
patient died.
patient died. Have a look at this, the last paragraph. Very recent judgment. Following Ajay Chaudhary, then Deepak Mali, everything. Everything has been said that yes, Rakibuddin, right law, everything right. At the end of it has been mentioned that whatever means, it does not stop the government. The last paragraph, which is the last paragraph. Wouldn't this make Ajay Chaudhary useless? The power of the authorities are there.
Always pending a considering effect. Fresh order.
Doesn't it make Ajay Chaudhary useless?
Yeah, redundant.
Everything. Even the office member. If they had the power, let them exercise, then it would be a. But
So where is the question of my lord? Again, placing him under fresh order. My lord, in this case, lordship had the occasion to hear this matter, my lord. Last time, lordship was pleased to direct the state to file an affidavit
My lord, we have filed yesterday. my lord.
indicating the position of the disciplinary proceeding, and they have done it, my lord. They have also indicated the
what
order.
is the status?
My lord, we have filed the affidavit yesterday, my lord.
What is the status? You must be knowing
The
it.
proceeding is
Vijaya.
going on.
Process is going on, my lord. And my lord, we have stated in our affidavit, this, the authority, then it another 3 months' time to complete it.
Hmm?
Because the writ petitioner, my lord,
Hmm.
on the last occasion, even he has short some time. And my lord, because of his persons only, my lord, we have to change the IOs.
Actually, my lord, these were actually what had happened. First, one IPS officer by name MS Indira Burua was appointed as inquiry officer. My lord, when the CID, the criminal side was examining the matter, she was supervising the case. So we said if she is there, then it will naturally cause prejudice. Therefore, based on my representation, they changed. Subsequently, my lord, they committed the same mistake by appointing her successor, Lassi Days Burua. Then, my lord, we made a similar representation. Now they have replaced him. Now the present one is one Imdadul Hussain. So under him, the proceedings are good. My lord, when they appoint somebody who had earlier dealt with my file, naturally, my lord, they should have taken note of that. It's not my fault. But my lord, the proceeding is going on.
Proceeding is going on.
My lord, here, if your lordship would kindly take note of the fact, 17/6/21, I was placed under suspension. Then, my lord, first action which they took was on my lord 8/11/21, they hold the first hearing. Then on my lord, in the meantime, I approached the learned single judge on my lord 26/11/21, my writ petition was allowed. Against that, state preferred an appeal. And in the appeal, my lord, taking note of the fact that the prayer of the state for filing affidavit was not granted. Therefore, the division bench of this honorable court interfered with the order dated 26/11/21 and remanded the matter back to the lordship. And the division bench also said, my lord, that the ground, whatever has been taken in the writ appeal, this should be the ground which they will be arguing before the court. Now, my lord, we are not assailing the disciplinary proceeding. We are assailing, my lord, the continuance of the suspension. Now, since 2000, June 2021, now it is almost, my lord, 2 years. So it has assumed the character of a, my lord, punitive. So whether, my lord, even minus Ajay Chaudhary also, my lord, I think our departmental circular are good enough to, my lord, take care of this situation. Now, my lord, the other day, lordship posed one question in view of para 22 of Ajay Chaudhary, how can we do it? Now, if a lordship could kindly come to Ajay Chaudhary, my lord, the facts in the Ajay Chaudhary. If a lordship could first come to para 1, my lord. Ajay Chaudhary, leave granted, appellant assails his suspension, which was effected on 39/2011 and has been extended and continued ever since. Then my lord will kindly come to para 2. Last sentence in para 2, my lord. Thereafter, third extension of the appellate, sorry, before that, between placidum C and D, on 28/12/21, the appellant suspension was extended for the first time for a further period of 180 days. This prompted the appellant to approach the Central Administrative Tribunal, and during pendency of the proceeding, the second extension was ordered with effect from 26/6/12 for another period of 180 days. The challenge to this extension did not meet with success before the CAT. Thereafter, third extension of the appellant suspension was ordered on 21/12/12, but for the period of 90 days. It came to be followed by fourth suspension for yet another period of 90 days with effect from 22/3/2030. So, my lord, that's why, my lord, in para 22, this view was taken in my approach.
No, all these extensions were given,
Yes,
but there was no issuance of a memorandum.
yes,
It was not that.
yes, it was not there. So what I'm saying is, my lord, para 21 of the Ajay Chaudhary, it says that within 90 days or 3 months, whatever it is, my lord, the charge memo has to be issued. If it is not given, then, my lord, they will get the benefit of something called akin to default bill. Now, my lord, even if in a case if charge sheet is given, Even then, my lord, there is a requirement of reviewing the suspension order at the end of 90. That is how, in my humble submission,
Ajay Chaudhary, does it say 90 days?
3 months.
Reviewing?
Months. 3 months. 3 months.
No, reviewing.
Yes. Within that period, if memorandum of charge sheet is served, a reason order must be passed for extension of the suspension.
So there is no period
No,
mentioned.
no.
This
no.
period has been brought in by this circular office memorandum.
Yes. Now, my lord, now here in our case, my lord, my humble submission is 17/6/21 being the date of suspension. So within, my lord, 3 months, the charge sheet was not filed. Charge sheet was filed on, my lord, 24/11/20. It is beyond 3. So I'm entitled to get that back. Neither the charge sheet was filed, neither the review took place. And my lord, the review order which my learned friend has annexed in the affidavit, my lord, these are perfunctory. My lord, if your lordship will kindly see, a reasoned order must be passed for extension of suspension. That means, my lord, they must take note of certain facts. Why they are extending this?
Where is the affidavit? This affidavit
Yes,
is not.
it's- Affidavit they have filed, my lord, on 19.
My lord, we have filed the affidavit yesterday, my lord. We have filed even, I have done the e-filing also.
E-filing mode.
Both, my lord, hard copy and e-filing, my lord. So that, my lord, it comes before your lordship. Yesterday only we have done it, my lord. Yesterday was the first day of the, after opening, my lord.
But Mr. Chaudhary, what do you say? All these exercise will become a futility.
Yes, in view of the division bench. The only thing is, my lord, their liberty has been reserved for the appointing.
Becomes
authority.
useless. The moment I give it, if they want it again tomorrow, they will do it.
Whether any
The
peculiar-
right which is-
whether there was any such peculiar facts in that case that I did not know.
No, that has been given. There's the declaration of law. Why don't you look into it? Let's see something can be done.
I can
Because
look
that
into it.
affidavit is also not here.
Yes, yes,
So something has to be done. Otherwise it becomes a useless thing.
yes.
You see, otherwise, no, small matters they won't. But the big matters of this type, they would obviously the next day they will do it.
And in this case, my lord, in the criminal investigation, nothing has turned out against. They filed charge sheet. There is no, even in supplementary charge sheet also they have not found it. My lord, I would respectfully submit, Ajay Chaudhary judgment has to be treated as having created a legal fiction.
Not
Something
only
like-
that, Ajay Chaudhary is a judgment under Article 21,
Yes, yes,
a right of speedy trial which is given in Hussain and Khatun,
Ah.
that has been brought in
Exactly.
within the ambit of this.
and secondly, my lord, in Ajay Chaudhary, Supreme Court has also taken note of the fact that the earlier division bench did not interfere with this suspension order, but the court was doing in this case. That also in para 21 towards the later part, my lord, that is indicated. In substance, my lord, the protection available under 167(2) has been made applicable.
So the
here, my lord.
right enemy is under Article
Yes.
21.
And under 141 is the law of the land.
Hmm.
So therefore, I am saying, my lord, it's a legal fiction. Once there is a legal fiction, it is the duty of the honorable court to give effect to the fiction. And what I can do, my lord, I can go to the judgment. You can have it on
Because it's useless otherwise.
Tuesday or Wednesday, my lord. Monday is a holiday, my lord.
Tuesday.
Monday 26, my lord, a lot of my matters are fixed, my lord. 27 or 28, my lord.
27, there's a lot of matters, no? One matter,
26, my lord,
one
division,
Mr. PK.
lot of matters. my lord.
Let it be 27, man.
Chalo.
Oh, all right, let it be 28.
28
28,
also no problem.
My lord, that citation my junior will take, my lord.
Yeah, you have it.
Or he has taken note.
You've taken it. That's fine. Although yesterday I passed an order.
Let's
I
see. my
passed
lord,
an
if there
order
is-
on the question of what has happened in that case was 3 months was extended. There was an order passed by this court. There was an extension being given for 3 months. And after that, there was no, the extension ended on 28/12/2022. There was nothing else done. Then the matter came up, when the matter came up before this court on 12/4/2023, I asked them, what have you done? On that very date, they passed an order of granting an extension from 5/8/2022 till finalization,
antedating.
without taking note of that they have already granted an extension.
And my
So,
lord, the extension is not perfunctorily done, that will not be, it
Ah.
must be a reasoned order.
so that is why I have noted out there
Yes.
that it has to be reasoned and it can't be in a perfunctory
That
manner.
I am tempering with some weaknesses, that I have abused the authority, something has to be there. Merely, my lord, saying extended will not, this is a reasoned order.
It has to have some reasons why it is
Yes.
necessary,
Yes.
that there is a case of tempering.
Ah.
It's
That
something
it's a
like
case
that.
of trying to influence the weaknesses or something.
Like in the other case that day, on the question that there was only minor penalties, that's
Yes.
teacher's case.
Yes, yes.
It was minor penalty, which comes under 1, 2, and 3, where the
It could
The
be
question
censure
of-
also.
stopping you from joining out there doesn't.
My lord, to be honest, that aspect we also overlook.
Huh?
Even I overlook, my lord, let me confess.
Yeah.
That I never thought that it is for a minor penalty. Only when I told my Mr. Deka was assisting,
Yeah.
I said it is entirely court sorted. We have no role in that. We overlooked it. my lord. Yes, it's for minor penalty, censure.
So where is the question of
No.
not allowing you
In
to
fact, my
function?
lord, suspension you cannot resort to unless the, proposed penalty is a major penalty. In substance,
And
my
that
lord,
is that is a
government
part of the
circular says so.
minimal.
Hmm.
That no suspension should be given in respect to minor penalty.
Yes, that the manual of departmental proceeding there,
Yes.
yes. So, my lord, I told him that we really overlooked it.
But Mr. Ken Chaudhary, the learned senior, assisted by Mr. J. Patwar, Mr. Ardor appears on behalf of the respondent state of Assam. Mr. Ardor has submitted, they have filed an affidavit yesterday by e-filing.
Both way, my lord. We have done hard copy also and e-filing.
They
No,
have
no,
filed an
copy has been
affidavit
served upon
yesterday,
us.
taking into account the same, let the matter be listed again on 27/4/2023. And 28, we'll have it
28, my lord.
28/4/2023 at 2 p.m.
My lord.
My lord, my lord.
2
Deep love.
p.m. The registry shall enclose to bring on record the affidavit.
44.
Oh, in this matter, Mr. Das?
Yeah.
H. Das? Yeah.
Here in this case, my lord, petitioner, my lord, retired from service 31/12/2020, my lord,
Hmm.
and 28 years service, my lord.
Then
1493 thereafter he was, my lord, engaged on masteral basis electrical mystery, my lord. So, my lord, he is not able to get his, my lord, pension, etc. my lord. That's why I have approached this honorable court and
master roll.
master all. my lord.
He is seeking regularization first, my lord.
Huh?
He is seeking regularization. Then
It's-
sanction.
You are seeking regularization.
No, but retirement benefit, obviously, my lord, it has to be regularized first, or benefit has to be given, my lord.
No, as per the 2003 or 2013,
Yes.
it is master roll,
Master roll, my lord.
not confirmed.
Not confirmed.
So not confirmed also if a person has 20 years.
He has received, my lord, some benefit also. Master worker, my lord, because, my lord, as I have seen here, office order, he is able to receive his, my lord, return other benefit also.
No, my lord,
lord.
he is not confirmed. That is what we stated in our affidavit.
What have you got? Terminal benefit.
My lord,
Service
Ah,
gratuity,
you have got the terminal benefit
yes, my lord.
as per 152.
he has received GPF and
You are a work charge,
Works as, my lord,
not master roll.
not pastoral. Against the, my lord, there was pay scale also mentioned in my appointment letter.
You got pay scale.
Yes, my lord. That was there, as I have annexed here, my lord.
Now, you
Annex
were
R1.
given the pay scale in terms with that Upendas.
no, my lord, Upendra is now, where is your,
When did you get your pay scale from?
No, like, at the time of appointment letter, my initial appointment, there was pay scale mentioned. Annexure 1, page 12.
work charge electrical mystery, my lord. He was appointed as.
How a pay scale is being given to a person who is temporarily appointed without a selection proceeding? How are this thing?
It was in the year 94.
It was 94.
94 law was not there.
It was always there, my lord.
Huh?
My lord, but it was not against any sanction post, my lord. They have given a pay scale, but my lord, it
How
was
can you have a
work
pay
charge-
scale? How can you have a pay scale against a non-sanctioned post? A pay scale is given under a ROP. ROP happens only in respect to a sanctioned post.
Sanction post.
He was in work charge electrical mystery,
Huh?
but he was in a work charge, my lord.
This is what, nah.
And my lord, I have also annexed here, my lord, his retirement coordination letter also, page 25, annexure 8.
25.
25, annexure 8.
So you were discharged also.
This is subsequently again reinstated. Again reinstated,
When?
because there was a case filed before this honorable court, my lord.
Now you are discharged from your duty with effect from 31/10/97. What is this?
But
95.
earlier order, my lord, can you please your lordship?
91, 31/10/1995. 1 day notice, you are discharged.
Well, annexure 3, page 16, my lord. Earlier order.
This is a interim order.
Interim order.
Interim order, does it happen anything? Goodness. You again reinstated.
And thereafter, officer he is reinstated. In person to the order passed by the Honorable High Court in civil case number so and so.
With effect from 1/11/1995. So there is a break of 1 month?
1 month.
No, no break, no,
No break.
no break. You were discharged on 31/10/95 and you were reinstated on 1/11.
Yeah,
So there is no break. Now, would you not be entitled to pension in terms with that particular notification? 93. Yes, you got that book at last. 152 or 152, just read after 152, there is a notification. Office memorandum.
Temporary government servant.
No. Then in that page, the next page. On top.
Pension Public Grievance Department, Office member. In continuation of the department, OM dated 96, it is reiterated that the said OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pension repayment. In terms of the and even my lord, in the judgment of the Prem Singh also, my lord. In the judgment of the Prem Singh also, that portion has been discussed clearly, my lord. I have already my lord, pointed out earlier also. And in this paragraph, that is specifically mentioned, my lord.
Paragraph 34.
36, my lord.
Third.
36. There are some of the employees who have not been regularized in spite of having rendered the services 30, 40 or more years, whereby they have been superannuated. As they have worked in the workers establishment, not against any particular project, their services ought to have been regularized under the government instruction and even as per the decision of this court in the Karnataka versus Uma Devi's case. And this court in this said decision has laid down that in case services have been rendered for more than 10 years without the cover of the court order, and as one-time measure, the services be regularized of such employees. In such facts and circumstances, facts of the case, those employees who have worked for 10 years or more should have been regularized. It would not be proper to regularize. It would not be proper to regulate them for consideration of regulation as others have regularized. We direct their services be treated as a regular one. However, it is made clear that they shall not be entitled to claiming any dues of difference in the wages had they been continued in service regularly before attaining the age of superannuation. They shall be entitled to receive the pension as if they have retired.
Mr. Das, for passing that order, na, this court, I am still an additional judge. I have to be permanent. Then I have to go to the Supreme Court. This is 142 exercise of duty.
According to me, my lord, this observation what has been there and in this.
You see, this observation is based upon Umanevi's paragraph 53. Paragraph 53 says that those people, whatever mean, this judgment should not, because Umanevi category, there were two questions in Umanevi. The first was the question as to whether the courts under 226 can direct regularization. Supreme Court says no, you can't. And secondly, as to whether the earlier period has to be taken into account, that was also negative. But in paragraph 53, the Supreme Court says that, look here, whatever we have said is said, but there are various persons who have worked for such long and have got their regularization without any help of courts or anything. Because you see the concept of what can be regularized and what cannot be regularized also explained in Umade.
Yes.
So those who have been working out there for all these years and they have been regularized and without there being any court order, this judgment shall not affect. This is further developed from there. That is to be regularized. But does this court have the right now to direct for regularization?
No. Regulation, your lordship.
If I can't, so your entitlement has to be without regularization.
Without regulation.
So only on the basis of that,
This notification.
and that is not your case.
Yes.
Because you have just come to know.
Yeah. But I have already mentioned more than 20 years. That is there.
That you have mentioned. The other part you have
Other
not
part
mentioned.
not. not confirmed also that statement is not there.
Yes, what do you have to say? Within the come within the ambit of that office memorandum?
My lord is referring to 89.
Not 89. The other one.
190. 190.
This is the reason why this 20 years has been brought in. Then came Sanjita Rai, wherein you were subtracting 6 years. Well, Mr. Dhar, on what basis are you giving those people 20 years, 26 years? Wow, how did this particular Sanjita Roy come into existence?
Yes.
If a person is otherwise a confirmed employee,
Confirm.
he is already in the service,
Yes.
then it will be regulated by 108.
Yes, consider it.
108. So he'll be automatically. Why you are having this 20 years? 20 years comes from this.
Yes.
And above this 20 years, you by another notification in 2014, you added 60.
Yes.
And that was struck out
They were struck out
by Sanjita.
Sanjita Rai. It is there.
Chalo, we'll have it on some other day. I have one judgment to deliver.
My lord,
Yes.
only one thing, my humble prayer, my lord. Here, ultimately, in this case, the finance, they have to come. They are not a party here. Because finance is required. Because, my lord, for this thing, ultimately concurrence will come from finance. So, my lord, they also should be put on notice, my lord, that about this, my lord. So, let him implement the finance department. My lord is taking up the matter on the next.
No finances, council nearby. Yes, Mr. Das, why
Yes.
don't you get,
Yes, well, I'll
you'll do it by hand.
no by
Yeah.
application. I because it is already old case. So by hand it
Let us look into it with the finance. Any urgent matters? No, no. We'll have it on some other day. Oh, madam, your matter. Yes, where is Mr. NK Dutta? That matter needs to have been called for. Wait, let me finish up that other matter. Where is Mr. NK Devnath? Oh, no, Mr. Kumar was there for the PNRD. Only one issue was there, 21. Isn't that the case, madam? Yes, Mr. Kumar. Hearing on it. 21.
Your lordship, I have received some instruction, your lordship. May kindly peruse it.
You got the record?
This is the instruction, your lordship.
What is your instruction?
Your lordship, that the speaking order was passed in compliance with the order dated, your lordship, the 11/2/2019 of this honorable court passed in the writ petition, your lordship. Your lordship will find the order in the page number 25 of the writ petition. The honorable court's order.
This was the order by which the order of removal was penalty of.
No,
removal of
no,
the-
that order is okay, but on 18th of September 2020, you passed this order.
Yes, sir.
I'm
Before that,
only asking you, is it the order passed by the governor?
your lordship, before that, the speaking order was passed here by the commissioner. Since the commissioner is the appointing and controlling authority of the grade 3 employee, he's a grade 3 employee.
Can the commissioner exercise the power under Rule 21?
Your lordship, your lordship,
No, it is not possible. Then how can you exercise this thing? You want to do whatever you want to do it.
yes, sir.
But it has to be under the name of the governor. Because the governor, you see, it categorically mentions that the governor reserves to himself the right. Whereas if you see Rule 67, the governor has delegated the power to so and so, but not 21.
Yes.
And that is my simple question for last how many days, madam?
For probably it's been a month now.
No,
No,
month.
no, your lordship, on
Yes, last 2 days, yes.
days, your lordship.
Since 3rd of April. Lordship, last 2 days, yes.
My simple question is this, and you have not come up. Whatever order you pass, you
Yes,
have to place it before the governor or whatever may be. It has to be under the orders of the governor.
Yes, your lordship.
I'm not, however, saying that the governor needs to sign it. No, it
Yes,
has to be under the orders of the governor.
then your lordship, since he is a convicted, since he is a convicted, and since there is no
So that
interference.
paper
by the
cannot be
appellate
sent to
court,
the governor.
your lordship, lordship, my submission is that he's till the conviction order is continuing, your lordship, he's not entitled to the pension.
How? That power has to be exercised, no?
Yes, has to
Who
be
passed?
exercised
Who will exercise the governor?
under 21.
So the commissioner and secretary has to pass the order in the name of the governor. Who is it?
Not always expressly, your lordship,
Huh?
not always it is required to be passed in expressly that.
Mr. Kumar, you are the additional advocate general.
Yeah.
Don't make that submission. You are on live TV.
Yeah.
If you make that submission, it will be, what will people think that it never normally doesn't happen.
Lordship, yes, under Rule 21, the governor has the power, your lordship.
It's only the
Since
governor.
your lordship has taken the view that it was not passed under Rule 21, your lordship,
It has to be.
yes. Your lordship.
Because you see, 22 comes only for provisional pension, whatever may be.
Yes.
But 21 is the power by which you are going to do. What you have done on 18th of September, he says, hence he is not entitled to pensionary benefits. Can you pass that order? No. That order has to be passed by the governor.
In the name of the law.
Whether in the name, yeah, obviously in the name of the governor.
Yes.
The governor it does not.
Yes.
But you see the language he used.
Yes.
The governor reserves to himself
Yes.
that power.
Right.
Because pension is a very valuable right. For you, there is one judgment. Today, somebody gave it to me. very recent 2021 11 SCC 543, wherein there is a direction of imposing interest. The state government has complied with the direction for the payment of the outstanding in 2 branches. Insofar as the interest is concerned, we are of the view that the interest at the rate of 12%, which has been fixed, should be suitably scaled out. For the right to interest, the direction for payment of deferred portion of the salary and pension is unacceptable. Salaries are due to the employees of the state for services rendered. Salary, in other words, constitute the rightful entitlement of the employees and are payable in accordance with. Likewise, it is well settled that the payment of pension is for years of past service rendered by the Iman. Pension are hence a matter of rightful entitlement recognized by the applicable rules and regulations which govern the service of the employees of the state. And interest have been imposed. So you say that there is no order of the governor.
Your Lordship, my submission would be, Your Lordship, since Your Lordship has taken the view that that order is not passed under 21. Your Lordship,
No, how can you say this order to be a 21 order?
I'm not
You are
disputing,
saying
Your
this order to be a 21.
Lordship. I'm not disputing, Your Lordship. My submission is that, Your Lordship, the authorities should not be diverted from taking a fresh view.
Oh, you can very well take up not a fresh view. You want
The fresh
tomorrow
order.
to take the order of the governor, then pass the order. I'm
Yes.
not on that.
Yes,
I'm
sir.
not asking you not to. But you can't stop it on the basis of this order.
It has to go. The impugn order has to go.
18th September has to go. And accordingly, the petitioner's entitlement there will be there till you take a fresh decision in terms with it.
That liberty they will not require from the court. That observation is not required from the court. They
Otherwise,
can,
Your Lordship,
what-
it will be interfered.
there is a statute on, in terms of the statute, they are at liberty to take any decision.
So this court, don't you think should make it clear
Yes.
while interfering with this order?
Not to that extent that this is not an order.
And
under
because of that,
21.
there will be the state, for that, the state would not take, would be under the apprehension that should we take any action or not. We'll make it clear that they have to take the order. The order has to be under 21 from the, in the name of the governor. And unless this order cannot be done, because this can't be in terms of 21, it should not stop them from taking action. But however, you will be entitled to the provisional pension till such action is taken. In the meantime, get your appeal heard.
Not to, and yes, that is another, not that there is one more aspect. Here we were on that, as it is, the statute does not use the word conviction. The word used is finality of the judicial proceedings. And we were on, if your lordship observes on that point, probably under rule 22, will still be entitled to provisional pension, the appellant, the petitioner.
How?
Rule 21, lordship, of course, the power is already there. That one.
But has
the
your
governor-
conviction been stayed?
Lordship.
Has your conviction been
Conviction
stayed?
has not been stayed.
Huh?
Conviction has not been stayed.
Then you are convicted. You're
Conviction has-
simply, you're similar like Rahul Gandhi.
No, as I had submitted, word used is not conviction. It is, word used is finality of judicial proceedings. Whether culmination of, whether at conviction, on conviction, the trial, conviction is the finality of the judicial proceedings. That interpretation and our coordinate bench of this court, the judgment has been placed, has observed that as it is, there is an appeal pending against the judgment of the Honorable High Court. So the judicial proceedings has not attained finality.
Twenty-two says where any departmental or judicial proceedings is instituted under Rule 21, or where a departmental proceeding is continued under Clause A of the provision thereto against any officer who has retired on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from the date of retirement to the date on which, upon conclusion of such proceedings,
Conclusion of
final
such
orders are passed, a provisional pension not exceeding the maximum pension as so and so on the basis of the date so and so and preceding the date on which. Now, madam, here the order was passed on the 21 by them. The moment I set aside that, your entitlement to get is on the 22.
Yes, we are claiming under 22. We are
So,
not,
but they can exercise the power under 21 still.
yes. they
And
can-
once they exercise the power under 21, it is not 22 which will help you. Only the conviction being set aside will help you.
Lordship, what I want to submit is that what they'll do now is that probably they will, if they pass an order under 21 now, they'll pass an order deeming it to be an order under 21. Then again, we'll have to fall back on the interpretation of the conclusion of the word use conclusion of such proceedings
Where? In 21?
in 22.
No, we are not concerned with 22. We are concerned with 21. Because the order which you are impugning is an order under 21, which they say.
No, there, this is not an order under 21.
This is an order under 21. 22 does not stop a pension. No. They say that you are not entitled to pensionary benefits, which is an order under 21, but not following 20. That's a different aspect.
But then what about provisional pension?
Provisional
shall be
pension, the
entitled-
moment 21 is set aside, that order is set aside, you will get under 22. No quarrel. But if it is a conviction, and conviction has not been stayed, then it will be 21. And then they can very well take action by passing an order in the name of the governor. And name of the governor is not like that. The governor has to, it has to go to his office.
And understand. Lordship, then and it'll be in conflict with 22.
No,
because
it won't.
so far as the-
22 is an interim provision.
Yes, for entitlement of provisional pension during pendency of the judicial proceedings. or the
Judicial
departmental
proceedings have
proceedings.
culminated.
No,
Because 21 says on the
judicial,
date of conviction, see
No, no.
21, the governor reserves the right to himself, the right of withholding or withdrawing of pension or any part of it, whether permanently or for specified period, and the right of ordering the recovery from pension or whole if in a departmental or judicial proceeding, the petitioner is found guilty of grave misconduct or negligence during the period, including service. Now, as of now, there is a conviction. The conviction has not been stayed.
pensioner is found guilty of grave misconduct or negligence during the period of his service.
You may challenge 21 on other grounds then, that it is not a case of misconduct or whatever may be. But 21, if it is done, it has to, all the power of the governor, it's an administrative power, the governor can do whatever it can do, and this court can only look into within the permissible limit of judicial review.
Yes,
But
21, the governor
this
has the
order
power.
is an order of 21, not 22. 22 is only a proceeding by which there is an interim provision that till finalization is reached in a judicial or a departmental proceedings, you'll be entitled to the provisional pension.
Yes, that is.
Now, the departmental proceeding is not there, but the judicial proceeding, there is a finalization, but there is no order being passed.
Lordship, judicial proceeding has not attained final, there is no finalization of the judicial proceedings has not yet.
As of now, you have been found guilty.
No, that is not, since the appeal is pending, can we say that?
Yes,
This is the culmination of the
there is no
judicial
stay to the
proceeding.
conviction.
No, that is not what the Lordship, the judgment of the coordinate bench of the honorable court.
Coordinate
As well
bench,
as the Lordship-
did the coordinate bench take into account to rule 21? Whether before the coordinate bench, there was an order challenge which was passed on the 21? No.
Lordship, probably there was some order withholding the pension.
Withholding the pension,
Yes.
provisional
He was-
pension
he
on the
was
ground.
getting the
But whether
provisional
there was an
pension.
order to that effect. Only order to. Anil Mohanto,
No. Lordship, order passed in WPC 1782 of 2014.
where is
It's
that?
not a- Or judgment dated 12/2/2015.
Where is it?
The copy of the order is there. It's there on the.
Oh, got it. Yes, let us see this order.
Yes. On the third page onwards, in order to appreciate the arguments advanced on behalf of the parties, it's necessary of that. Route 22.
Madam, this court finds the difficulty how the coordinate bench have taken note of Rule 10 of the discipline and appeal rules. Because discipline and appeal rules, Rule 10 will only apply in respect to a government servant. You see, notwithstanding anything contained in Rule 9, where a penalty is imposed on a government servant on the ground of conduct which has led to his conviction on a criminal charge,
It can,
then the decision may consider in the circumstance not to pass an order to that effect. That is a disciplinary authority can do to those. But
yes.
then also here power has to be exercised only by the governor. That aspect has not been taken note of.
Lordship, just one submission. What the opinion of the presently what has fallen from the honorable court is that the impugn order, even though it appears to be an order under Rule 21, but it has not been issued under the name of the governor, or it has not been issued by the governor. That is why it has to go. That is what the view of the appears to be, view of the honorable court. Now, if that view is taken, probably that will render Rule 22 obvious, because my right under Rule 22 to receive provisional pension, unless till finalization of the judicial proceedings, that will go. My right under, I'll be deprived of my right under Rule 22.
No, madam,
Lordship,
no.
submission.
No,
Lordship,
no,
I
no.
want you
Madam,
to
you are
finish.
not understanding.
Just one, what I'm,
Rule 22 is an interim provision.
yes,
That
yes,
till
yes,
culmination of the proceedings
yes,
or till passing of the orders in respect to disciplinary proceedings,
yes.
which are continued. Because if you see 21, the first portion of 21 is categorically mandated that if proceedings were started prior to when the person was in service and thereafter he retired, it will be continued without any fresh order. Now,
Understand, Lordship.
now after this, in this case, if there is a conviction, if it is there, and the power is being exercised by the governor, then in that regard, the question of you getting under 22 does not arise.
Lordship, Lordship will kindly bear with me. What I'm trying to submit is that the statute has not, legislature has not used the word conviction. It is very clear from the Rule 21 and Rule 22. Now, where is the word conviction used? Rule 22 uses the word conclusion of judicial proceedings. As we have
No,
read.
why were into Rule 22?
I'm coming. I'll come to Rule 21 now.
Hmm.
Rule 22 says conclusion of such proceedings.
Hmm.
Then Rule 21 says found guilty of grave misconduct. Now this pronouncement of guilt, this will attain finality only on culmination of the entire proceedings, and the proceedings culminates until the appellate court has taken a final view, and that is what is the mandate of Section 393 of the CRPC.
If in a departmental or judicial proceeding, the petitioner is found guilty of grave misconduct.
Yes, yes. Departmental proceedings, we are not concerned here because the order of penalty,
Judicial
which,
proceeding, you have
order
been
of
found to
penalty,
be.
order of penalty which was discharged, which was imposed on me, that has been set aside. They were given liberty to draw up fresh proceedings. They did not do it, and the criminal.
No, whatever may be, madam, you
Yes.
have been convicted out there and you have been found to be guilty of grave
Yes,
misconduct.
convicted. I cannot dispute that. It's there on record. I've been convicted.
You have been found
But-
guilty.
But as I'll be at the cost of repetition, word conviction is nowhere used.
Not necessary.
And, no,
It
no,
is-
and the
If you are
final,
found guilty of misconduct,
the pronouncement of guilt by the trial court is not the finality of the judicial proceedings. Finality will be attained only when the only on exhaustion of my final remedy up by the higher at the higher forum, before the higher forum, that is the honorable, whatever apex court. But
let us
Yes.
assume, where does the apex court say that?
yes, even Lordship, even in that the judgment.
No,
by
no, forget about
Honorable
that
Justice,
judgment. Show me the
that,
apex court
continuation-
where.
That continuation of that appeal is the continuation of the trial.
So it may be a continuation,
It is the continuation of the
meaning
trial. So
thereby a person concerned, are you saying a person is convicted? Just for
Yes.
example, he's convicted of a case of rape and everything. Appeal has been filed and appeal is pending.
Yes.
He got a bail.
Yes.
Thereupon, the appeal is filed here, it takes 10 years. Then another 10 years in the Supreme Court. Are you saying that this 20 years, there's nothing out there? All these things happen, he'll be entitled to pension, provisional pension?
that is
If
what the
there's an
judgment-
order, the governor cannot pass an order?
Lordship, Rule 21 will probably come.
No, does
after-
the filing of an appeal stay the finding of guilty?
As it is, Lordship, there are various judgments. Even these judgments says appeal is the continuation of the trial.
So what?
So
The
un-
judicial proceedings, you see, the judicial proceedings having not end is a different aspect of the matter, which is there in 22. 22 is only a interim provision. 21 is the main provision. The power is there with the governor. Yes, you are found guilty, you have to do it. Unless you get a stay on the conviction or the sentence, no conviction. And you filed that application, you only took the bail. The court did not. In India, filed the application for stay of the conviction.
yes, we did not
And
find,
the court, with good intention or bad intention, the court have decided that and said that no, you are not entitled to intention or conviction, stay of the conviction, but you will be only entitled to this.
Lordship, I was only on that aspect, as it is the legislation says that it's conclusion of judicial proceedings, and conclusion of judicial proceedings.
Where is the
does not
judicial
include-
proceedings, the appeal, filing of an appeal would lead to the pendency, there is a stay to the
And in
conviction.
my humble submission, Rule 21 will come after that, after exhaustion of my remedy exhaustion of my remedy to get provisional pension under Rule 22 is exhausted. After that is stopped. After that, Rule 21, exercise of power under Rule 21 will probably come. Lordship,
Why?
if your Lordship gives me one more day, I'll submit on. Rule
Okay,
21
we'll
and
have it.
22.
No problem.
Yes,
We'll
next
have
week
it on
any day.
9th of May. 9th of May.
Yes, yes, thank you.
Always. Take it. The request of the learned counsel for the petition of matter sent adjourned till 9th of May. Yes, Mr. Mehdi.
Before the Superintendent CD file, you understand we check it. That's already my.
Which matter?
Check there.
Which matter? That matter.
What you on that matter? Affidavit has already been endorsed there. So when this before the matter came, that day my affidavit was not checked there. That is the check.
We'll have it on 25th. I'll pass the order in your presence. I've half of the order. Primo
Half of the one was already.
75% of the judgment. He is not the stenographer who had taken it. There's another one. I'll ask him to take it up on 25th.
25th. 25th.
25th.
Okay.
And prior to that, ask him to get me. Huh?